Lord, item number 4, Lordship, 4 and 6, Lordship. Lordship, in this case, Lordship, they have filed an objection, my Lord, against our application for condonation of delay. Lord, we are filing our reply affidavit today, Lordship. Let it be bringing on record, Lord.
You are Mr. Sharma.
I'm Mr. S. Chetia, Lord.
Yes, Chetia, appealing for the revenue appellant. The praise and is granted 2 weeks time so as to file a counter to the objection filed by the respondent in the application seeking condemnation of the list of 2 weeks.
I am for the respondent.
Deeply over.
What about 6?
4 and 6.
4 and 6,
Four and
same,
six.
Lordship.
May I please your lordship, but that's to mention item number 9, lordship. Actually, on the last occasion, we are instructed to produce additional documents, lordship, for which we have filed RTI. But the thing is that lordship, they need to take 30 days time for delivering us, which has not been
Counsel
passed
for the
yet.
appeal.
Okay, so
Petition submits that
matter may be taken out of the.
the process for procuring the additional documents from the bank has been started by way of an application under the RTI, which would require at least 30 days time. List, she does praise that the matter may be adjourned, list of 4 weeks as well.
Malad, item number 17, Malad. Due to some personal information, can it be taken up some other day, Malad? With
There is
consent of the.
no request, no
Malad, that, yes, Malad.
Why should we-
Bar election is going on. I'm a candidate.
bar election, you are contesting.
That is fine.
List of 2 weeks as.
Obliged.
May it please your lordship. Lordship, I beg to mention item number 22 and 23, lordship. We have also furnished the adjournment slip also, lordship. Some difficulties today, lordship. After
22 and 23.
lordship, lordship.
Your good name, please.
K. Gogoi, lordship.
Mr. K. Gogoi. You are for the appellant state,
Lordship, lordship, lordship.
appearing for the state as furnished and circulated an adjournment slip. Why do you want an adjournment?
Lordship, today some difficulties, learned advocation, some difficulties is there. So,
List of 2 weeks,
lordship, after 3 weeks, lordship.
3 weeks.
Lordship. Obliged, lordship.
May I please your lordship? I beg to mention 25 to 31, lordship.
Why?
Adjournment, lordship.
Why?
Some personal difficulties it comes up, lordship. Can it be on some other day, lordship?
Gentlemen, these are only hearing cases before us now. We are
Lordship,
not adjourning them. Argue the matter.
Lordship, the engaged counsel, B. Kurkasto, is unable to come to the court. He has been preparing the matter, lordship. Can it be 1 week, lordship? Humble prayer of him.
We hardly have 30 matters listed, and out of them, if you get 8 matters adjourned, what should we do for the whole of the day?
Lordship.
Let us know.
Lordship,
It's not fair. We'll see. Let the matters be called out.
May it please your lordship. Lordship, I beg to mention for listing a IA for condemnation of delay, we have filed appeal also.
Tuesday, Wednesday, whenever.
Obliged.
May I please, lordship? Lordship, I beg to mention item number 24, lordship.
Yes.
Due to some personal problem, my senior will not be able to appear today, lordship. Maybe adjourn for 2 weeks, lordship.
We have denied prayer to other council. Why should you be granted prayer? This indulgence, let us know. Who is not here?
Mr. K. Bhattacharya, lordship.
You are here, you argue the matter.
My name is,
Let the petition be called out.
my name
Yes.
is not there, lordship.
Don't worry, let it be called out. We'll see.
Much obliged.
Item number 1 for orders.
may it please your lordship.
Yes.
The meeting was held, of the infrastructure committee was held on last Tuesday.
Hmm.
There are some positive decisions.
Positive indications.
Yes, my lord, and the IIT, they have also, my lord, promised that within a week, they will file, they will submit the report. That is a drawing.
Open this room. Open this.
Because PWD wanted the working drawing from the IIT, they have agreed.
Okay.
Delay. They have, my friend has said that drawing has already been.
Already been received.
No.
No.
No, no.
The IIT said, IIT, they confirmed that within 1 week, they will give, in the meeting, they said,
Fresh drawing you want.
working drawing.
Working drawing.
Drawing is there, working.
Meeting of the building committee
Lordship.
was convened as a consequence to the direction given by this court on 16/5/2023. During the course of meeting, the Indian Institute of Technology, Guwahati, is the competent officer of IIT Guwahati has agreed that the working drawing as requested for by the PWD will be provided within a week from the set date. The building committee has also advised the registry to coordinate with all the stakeholders and take necessary steps for obtaining the working drawing from the IIT Guwahati. Thus, the requisite drawing be provided to the PWD simultaneously, the required acquisition of land of the, your client is a respondent or
Yes.
of the respondent number so and so,
Well, the
who has agreed to,
Yeah.
you are surrendering or you are, that is a acquisition under the act or surrender?
We're not very fussy about that also, madam. We are prepared to give the land.
Who has agreed,
Well and good.
who has agreed to give the land
Surrender, it is.
without any exceptions, the said process shall also be completed at the earliest, re-notify on 15 June. In the meantime, you,
Perhaps they'll-
construction of the road will enhance my buildings.
obviously, that value of your building will be.
Not very fussy about that.
Perhaps, my lord, the PWD has to come up with this, some sort of timeline, my lord, to complete.
Let the map at least be given.
Let the
On
working
the
drawing
next
come.
date, Mr. Nath will be
yes.
ready with this,
Yes.
with the timeline also.
Yes, yes.
It has
Highly.
been delayed sufficiently.
Yes, madam. But if the acquisition part is not there, then it will be faster because.
Or they are agreeing,
Yes, yes.
actually, their land value will be increased.
It will be.
That is a very sensible bargain, we would say.
Correct, madam.
Road is very important, my lord, because entire boundary of the High Court, the security issue and all these things, for that, the road is very important. It's vulnerable.
Totally blocked.
I can. No,
15 June.
Highly obliged.
Mr. Nath, here is Mr. Nath. What about the encroachments? There are few encroachments still.
Encroachment in the other side. My friend has said, we are now concentrating on the construction of the road. I'll also.
To find out if there are any encroachments, what steps are proposed.
Lodge.
Yes.
Lordship, flag X is the remand draft, Lordship, which petition appellant has deposited before this.
Demand draft is given, so that
No,
we
Lordship.
can now close the matter.
Yes, Lordship. A respondent will not, in future, she will not file any case against me.
No further claim for compensation.
Yes.
Or
Lordship.
maintenance, full and final settlement
Lordship. Deprivileged.
disposed of. Yes.
May it please, Your Lordship, the non-compliance of the order, my lord, at page 18, the operative part at page 21, my lord. For payment of ex gratia in terms of the prevailing notification, my lord.
Yes.
Lordship,
And the prevailing notification, my lord, I have annexed at page 12, my lord.
Let's see.
Lordship, the sanction has been accorded by the revenue department, Your Lordship.
Let's see. Give him a copy.
Not yet. Given it.
Give him one copy, please. Then I'll- he will have to be satisfied that it is in accordance with the scheme.
Scheme, my lord, at page 12,
3 lakhs has been sanctioned.
Yes, Your
but notification said for 5 lakhs. My lord, page 12.
All right, you file a counter to that. Then government council, MS so and so, has placed on record copy of the communication dated 23/5/2023, as per which the Revenue and Disaster Management Department has sanctioned annexing therewith copy of the payment financial sanction, as per which, a sum of rupees 3 lakhs has been sanctioned to the petitioner by way of compensation in terms of the order dated so and so. And counsel for the petitioner pays for time to complete his instructions and file an objection if so required. List after 1 week, 2 weeks.
Obliged.
Objection regarding quantum of compensation awarded if so required.
Wait, please, your lordship.
Yes.
Lordship, this case has a long and checkered history. And lordship can see this in page 114, page 114.
What is the order under contempt, sir? Let us see.
Order is, lordship, page 118, the operative portion, I mean the dismissal of the writ appeal. So ultimately, of course, the operative portion will find in the writ petition. Because that
What is the direction in the petition? To make payment of back wages?
yes, the pay back wages and take them into service. So this is in page number 57.
57.
57. Wherein orders of the termination were set aside. And the petitioner.
Third, issue notice to the respondents. Steps for service be taken in 3 days. Thereafter, process be issued. Rule is made returnable in. Four weeks. Only one respondent is there.
One
To the respondent.
Obliged.
If the appeal was dismissed for default, lordship, at the relevant time, counsel was not there, department counsel.
Company was,
Counsel for the department was not there during that period, lordship.
Council was not appointed.
Lordship, there is a delay of 269 days in filing the restoration application.
Issue notice,
Lordship.
the respondent. Steps service be taken in 7 days. Thereupon process be issued. Rule is made returnable in 6 weeks.
Lordship, much.
Ms. Gail, a mention was made on your behalf to adjourn a hearing matter.
Lordship, I have not.
No. Acha, the other side was this. Why this?
Right, with your lordship.
Seven.
Inform the honorable court that the appeal filed by one of the respondents against the same judgment has already been admitted by this honorable court.
Yes.
That's why I'm not pressing for any stay, but this appeal also may be admitted and
All right.
that with that,
Bits Pilani, equivalence.
lordship, yes.
What do you say, sir?
QC has not recognized this degree. Peace is recognized, but this
Your advertisement mentioned the institute should be recognized. There was no such reference in your advertisement
we are saying
that the degree should also be recognized by the. So that's an issue which needs to be examined.
Yes.
Admit issue notice. Everyone is represented.
Yes.
Maybe lordship that
I'm for one of the.
Which one, sir?
Respond number 4.
it will be tagged with appeal number,
That is my appeal.
lordship, 350 of
Who is there for respond number 1?
I am.
Mr. Swan, so for the respond number 1. Central Government Council. Deputy SGI, Mr. You are appearing for AICT. UGC. All right, mark attendance of all concerned. For 6, Mr. KL. For 4, Senior Council. Mohanta, Mr. KK Mohanta. For 3, Mr. Swan. Number 2. Union of India, Human Resource Development. Ask Mr. RK Chaudhary if he is appearing. Appear for the respondents, thus notice need not be issued. Connect and list with writ appeal number 350/2022.
Right, lordship.
What about the stay? Mr. Council, we can dispose of the interim interlocutory application.
I'm not pressing that application now because
Council
already been stayed
not-
by this court.
Mr. Kakoti does not press the application for interim relief 1122/23. Hence, the same is disposed of as not pressed.
May it please your lordship. My lord, at the foremost, my lord, before I begin, my lord, the respondent number. Respondent number 3, my lord, is not a contesting respondent, my lord. I will pray that it may be treated as a pro forma respondent, my lord.
You don't want service to be affected
My
on your
lord-
prayer and at the risk of the petitioner. We can do that.
My lord.
On your prayer and at the risk of the petitioner, we can.
My
Make that
lord,
observe.
let it be treated as a pro forma respondent, my lord. They should be supporting my case, my lord.
Number 3.
Number 3.
All right. Do you support the case of the petitioner?
No, I am appearing for the 1 to 4 and 5.
So she's,
3 is him. No?
what's your stand? All right, it doesn't make any difference, madam. You just provide a copy.
I already did that. That I already did, my lord.
Okay,
May it please your lordship.
yes.
The petitioner herein is a Anchalik Panchayat, my lord, and is agreed by a NOC issued by the deputy commissioner. And that NOC, I do not know from where the powers have been conferred on the deputy commissioner, but I presume, my lord, on the basis of 2 government notifications, my lord, wherein
the deputy commissioner has been empowered under the Cattle Preservation Act to regulate the markets and has been conferred as the authority under the said act. So far as my case is concerned, my lord, I am a panchayat, my lord. So far as the panchayats are the Assam Panchayat Act 1994, my lord, that is consequent to the 73rd constitutional amendment. And this local self-government or decentralization of powers up to the grass level, my lord, that is the about constitutional objective, and that was the purpose and objects of bringing the 73rd.
So your argument is that for a Gram Panchayat area,
My lord.
the deputy secretary doesn't have power to grant this permission. What is your argument?
My argument is that so far as the Cattle Preservation Act, that has been made applicable to the whole of the state of Assam.
And state, yes,
Yes.
yes.
Now, so far as the Panchayat Act is concerned, if this Cattle Act, so far as the authority, appointment of the authority, competent authority is concerned, if it is given to the deputy commissioner, then it divests the panchayat from its roles and powers under the
Under the
panchayat.
Panchayat Act, does the Panchayat have the power to organize such fairs?
Yes,
Let's-
my lord. Even under the constitution as well as the Assam Panchayat Act.
I know. Who has the power?
If my lords may kindly have the Assam Panchayat Act, my lord.
Yes, yes. Yes,
My lord, that is section 19, my lord, functions of Gaon Panchayat.
yes.
We have item number 17, markets and fairs.
Yes.
And if I may take my laws to the constitution itself.
The last time they even got medical and health under that. It is such a huge transfer for doctor. Permission of the Panchayati Raj was required. It was terrible. Public health ले आया ना ये.
Markets and fairs, my lord, under the Panchayat Act, it says, under item 17, regulation of fairs, including cattle fairs and festivals.
So where under the act, the deputy commissioner is empowered? Where is the act? Do you have the copy of the act? Cattle Preservation Act?
Cattle Preservation Act.
No, that is constitution. 243 लगाया उन्होंने.
The government has the power to appoint a competent authority
For what purpose?
for the purpose of implementation of the act.
Okay. Yes, Mr. Knight.
Well, this is page 33, the prayer.
Infringing on the jurisdiction of the panchayat.
No, well, the page 33, in the writ petition, they have prayed for, they declare the and adjust section 3A, section 10 and section 21 of the Assam Cattle Preservation Act 2021 as unconstitutional. Well, this act, they have not annexed. Highly similar to the act.
Yes, we are.
Plot.
Yes.
Well, the object of the act, but we'll come up with the.
Yeah,
reply.
we'll hear you.
Plot.
Yes,
Well, kindly see the object of the act, Lord.
yes.
To provide for preservation of cattle by regulating their slaughter, consumption, illegal
So this is
transportation,
basically for against slaughter.
slaughter.
Yes.
And particularly Malad, the cattle and section 3A, they have challenged. Section 3A kindly see animal market.
Hmm.
We are concerned with that, my lord. Animal market means a market, place or sale yard or any other premises or place to which animals are brought from other places and offered or displayed for sale or auction and include animal fairs and cattle ponds as duly licensed or recognized under a state act or any other law for the time being in force. Now kindly come to 6, my lord. Under this provision, that particular notification has been issued, they have challenged. Section 6, prohibition of slaughter of cattle in places other than a slaughterhouse. No cattle in respect of which a certificate has been issued under section 5 shall be slaughtered in any place other than a slaughterhouse duly licensed or recognized under a central or state act or any rules or regulations made hereunder or other premises as may be specified. Now, Lord, under this section 6, this particular notification has been issued 6, 7, 8 and 10. They have that notification they have challenged. Can you see 7?
Yes.
Prohibition on transport of cattle. The act provides that no person shall transport or offer.
So
for
these
transport-
provisions as per you do not deal with the holding of the fair or the place where the fair will be held.
True, my lord.
That is what your argument
My
is.
lord, my lord.
These are
Now,
dealing with transportation basically.
now the,
Now, what 10 says animal market regulation.
yes, my lord.
So 10, they have a grievance. Regulation of animal market within a panchayat area.
No.
Why should it be left to the panchayat?
Lordship. In respect of others, this act will not, is not to say about. But the section now, page 39 in the impugned order notification that they have challenged. This is delegated competent authority under this act. That
Yes.
under section, the director has been delegated. Section 8, the district magistrate, section 8, district magistrate of the concerned district. So the circle
We-
officer concerned, he has been
understand
given the power.
10 is district magistrate.
District
So
magistrate-
grievance which they've raised is
Lord,
that so far as holding of animal fairs are concerned,
Lordship.
within the panchayat area, as per the Assam Panchayat Act, the domain is of the panchayat, gram panchayat, Kam panchayat. That is what their argument is.
That is what they are just saying about.
Then
But for regulating the animal.
this is going beyond the constitutional mandate as per that.
No,
While your affidavit will
Lordship.
examine
well, fine.
and council appearing for this issue notice, Mr. Nath appears or you'll be appearing for 1,
1, 2,
2 and 4.
1, 2, 4 and 5.
1, 2, 4 and 5.
Five.
For 3 you will be appearing.
3, my friend was there. He is the standing counsel for the person, PNRD.
For respondent number 3, Mr. So-and-so appears. Copies of the writ petition be provided to then council representing the respondents. Number 6 notice will have to go.
6
Requisites for effecting service on the respondent number 6 be furnished within 3 days, 7 days, thereafter process be issued to check. Rule is made returnable in 3 weeks.
May I pray for an interim, my lord, so far as the NOC is concerned. So far the NOC with respect to only this panchayat.
Not
my lord.
without hearing, madam.
I'm not asking for a stay of the others, my lord. If I may,
Staying the NOC would mean staying the fair.
my lord, only the NOC, my lord.
This has a larger ramification, Bala.
My lord,
Let us file the affidavit.
Notice of interim relief as well. Notice on the prayer for interim relief as well. आइए तो नहीं है इनका. There is no आइए. Inside within the regulation they meant. There is a prayer. Read. Not stay. 35 years. Notice on the prayer for interim relief as well.
If I may just, my lord has already, I respect my lord, I'll go down, my lord. Just persuade, my lord, so as the NOC is concerned, even my friend should be supporting me because this NOC is not under the Cattle Act also, it's not under the Panchayat Act also.
Get the notice out. Has the fair been started?
Yes, my lord, they have
So it's
started on the basis
already
of-
commenced.
Without, my lord, without registration, my lord.
When was it started?
My lord, it was started, this was filed on 10th of May. It was started the Thursday prior to 10th.
So they
of
are
May.
already operating for the last 15 days.
My lord, and
To
illegal,
stop them in the midst of it without hearing, that will not be fair.
my lord,
Get them served.
I'm grateful.
We can give you a shorter notice if you want.
I will be grateful, my lord.
Rule is made returnable on 9th June, list on 9th June.
I'm so grateful.
Dusty service.
My lord,
kindly keep it on 12, 12, 13,
13.
13,
13, my lord, I'm not
then
available.
14. Let me have the instruction.
13 to 15th, I'm not available. If it is, can be prior.
Kindly on 16.
16.
16. Lordship.
Or even. I'm extremely sorry, my lord. Let it be 17 subject to.
17.
I'm grateful.
Be sure about the date, then let us know.
My lord, I'm grateful.
Okay. 17th is a Saturday.
After 16. After 16.
It's all right, my lord. It's an embarrassing situation now. If it was
16.
prior, I would have been grateful.
Lordship, 16.
16th. Lordship, this is appeal by the department, Lordship. Given the suggested sections, we can control. Should we call upon the other side? Lordship. The retracted statement. Lordship. All right. Lordship, notice may be issued. Notice may be issued.
There is no one indispensable in this world. ऐसा कुछ नहीं.
All right. Issue notice to the respondent. Lordship.
Let one lawyer be enriched.
Requisites if furnished within 7 days, thereafter process we should. Rule is made returnable in 6 weeks. ये वापस दे देना suggested questions.
This appeal.
Admit issue notice sent for lower court record. And steps for service be taken in 7 days. Thereafter process be issued.
Deeply.
Record is here. All right, so don't mention about the record.
May I please, your lordship? This matter will be filed against the impugn order passed by the family court Borpeta, your lordship, where the appellant was directed to pay rupees 10 lakh as permanent future alimony. Your lordship.
Yes.
The amount 10 lakh is high on my side, your lordship, and
Why? What does the appellant do?
he's
What
just-
is his?
He's just a service, he's doing a job in a small office, your lordship. Earlier, as per the,
He has a
Complaint,
wholesale shop, Maheshwari Agency.
no, your lordship, that shop has been closed, your lordship, due to the pandemic, your lordship, that shop has been closed, your lordship. Yeah. Your lordship, he has given his WS also, wherein he has stated that that shop has been closed, your lordship, and also the statement of his,
Did he file the affidavit?
yes, your lordship, I filed the WS, your lordship.
Lordship, the affidavit regarding assets and liabilities from the memo of appeal, what.
Neha Rajneesh affidavit was not filed.
No,
It
no,
was
so
not
Then
your lordship was not asked, your lordship, by the.
it is not required to be asked. That's the duty in this. But all right, the record is here.
No, my lord.
We'll call for the record, then we'll examine.
Yes, my
Your
lord.
lordship.
Send for the LCR list. The matter as soon as LCR is received.
Your lordship, till the amount may be stayed, your lordship.
No, no, no. Big
Because
no.
your lordship, they filed the execution
They have to
petition,
do
your
it.
lordship.
Offer
Next
something
day,
reasonable and we'll stay the
There is no
remaining.
prayer. There is no prayer for.
No prayer for
stay.
stay.
For set aside and modify, your lordship. I have
So
stated
we'll
that
not
prayer.
set it aside without hearing the parties. No? The final hearing has to be done for that.
Yes, your lordship.
So we'll make an observation. Since there is no prayer for stay, the respondent is free to execute the decree.
Yes, your lordship.
My lord.
You want us to make that observation?
No, your lordship.
No? All right. Let the record come with him.
A date may be fixed, your lordship. A date may be fixed, your lordship.
Whatever. When do you want the matter to be fixed?
This is Borpeta, it will come from Borpeta, your lordship. The next date is fixed on 19th of June, your lordship. If,
Execution pen.
Execution.
yes, your lordship.
16 June. All right.
Oblige, your lordship.
Deeply obliged.
No, this matter was listed earlier, my lord, your loss is granted some time, my lord, for single bench, but till now it has not been disposed of. My lord,
After your lordship's order,
Yes.
this matter was listed before the learned single judge. And the honorable single judge passed this order calling for the records of the case. So my lord, after that, because of some health related problem.
This Jayanta Ghosh is the same guy.
same guy.
Yes.
My lord, here,
No,
tender,
you don't know what same guy we are talking about.
okay. No, in earlier case, my lord, because, whether this, notice is in respect of SBD and long term, my lord, that was the, my lord, the call for minutes of the, meeting, my lord.
This was the order calling for the records of the case. After that, because of some health related issue, the single judge hasn't said.
Is continuing again. That is what the grievance is.
We have completed our hearing.
Hmm?
We have completed our argument.
You have completed your arguments. Let the rate be decided what can be
My
done.
lord, my lord, in fact, now bench is changed, my lord. They are good, but.
Changing of bench is not relevant. It will be decided by whatever bench is hearing the
My
matter.
lord, I have nothing to say, my lord, but the matter is, because earlier, my lord, division bench fixed the 12th of December. So, my lord, that was not disposed of. Then, my lord, we are in May, that is why, my lord, we have to approach again. And that we have received, my lord, that this tender, which was, my lord, settled later on, After.
All
they
right, then
got the order.
argue on merits. Madam, you are prepared?
Lordship, the matter is already in section before the single judge.
That we know, but we expected that the rate would be decided. It has not been decided, then what to do?
But the matter is getting listed in the cause list, it is coming. The single judge hasn't said. So any other court can take it. There is no issue in it.
He's not there for the entire.
And regarding the dispute was with regard to the quarterly payment. Whether the payment has to be made in four quarters or in 6 months at one go.
Admission stage. Only matter of being admitted in the hearing is that you can. Otherwise, wait for 10 days or so.
My lord, I have nothing to say, my lord, only your lordship may observe, my lord, let him be.
We'll not dispose of your appeal.
My lord,
We'll keep your appeal pending.
yes.
ये वापस देना होगा. The writ petition pending before the learned single bench has still not been decided. And counsel for the party respondent submits that the matter is being listed regularly and presumably the same would be decided at the earliest. Re-notify on 15th June.
My
May I please your lordship, in this case, your lordship, the wife respondent has filed an affidavit. He is also not interested to continue. There is no chance of reconciliation.
There is subsequent development, my lord, in this matter, my lord. As a result of which, my lord, the matter has been settled amicably to village which are in presence of elderly person, my lord. And
Okay.
in this context, my lord, I have filed affidavit, my lord.
You filed an affidavit?
Lordship.
Where is it? Call कर लीजिए affidavit मंगा लीजिए. If they now find an affidavit of dissolving their marriage by consent, will allow the appeal. Right? When did you file the affidavit, sir?
Affidavit, my lord.
When did you file it?
Already filed, my lord.
When? What is the date?
Date is, my lord.
The copy is up to me, there is no date, but March 2023. Maybe some defect or something. Then we can allow the appeal, gentlemen.
Lordship,
We should allow the appeal then. Dissolve the marriage.
lordship, lordship.
All right, get the affidavit. Okay. Sir,
I have also received, my lord, the permanent alimony also.
all right, you mentioned in the affidavit.
Already.
All right, give a copy.
My
Give a
lord,
copy of the
is there, my lord.
Allowed. Original मंगा लीजिए. This let them have. We'll just have a copy. Original they must have filed it now. Obliged. 16. Original position was not disturbed by the Supreme Court. Yes,
May I please, Your Lordship?
yes.
In this writ appeal, after issuance of notice, my lord, in November, an affidavit was filed by the respondent number 1, questioning the locus of the association, my lord, on 2 grounds primarily. First is, my lord, that my registration was valid up to 2018 and it was not renewed thereafter. The second premise is that, my lord, I'm not a recognized association under an OM that they have enclosed with the affidavit. My lord, my answer to the first objection on registration is that, my lord, subsequently, I got a renewal done from the registrar, which I have, my lord, enclosed with my application, with my reply to the additional affidavit, my lord, which your lordship will find at page 414. My lords have the
Yes.
page 414. This is issued under the Societies Registration Act.
Do you have anything to say on this aspect also now? Preliminary objection, or we should hear the matter on merits?
Lordship. My lord,
After,
what I was trying to submit before my lord is, on the date the appeal was filed, there was nothing, and that's a different thing altogether.
Nair,
I'm
the
not very
respondent's case is full of fraud.
I'll satisfy you,
Face of, yes, you try and do as much as you can.
Lordship.
But
My
try
lord,
your
the
level
fraud
best.
that was there, he has suffered for that. And my lord, that is now,
Yes.
my lord, after the punishment,
He
if
has
I may
not
say so, my
suffered
lord,
anything at all.
but what the honorable single judge has said, my lord,
Yes.
is
The order was not issued by the governor.
No, I'm not on that. The honorable single judge interfered with everything, my lord. But my promotion to the post of assistant executive engineer was protected way back in
21,
2005.
2005.
5 itself. That I said, my prayer before the honorable single judge was, my lord, if
Only
my
to that
promotion
extent.
is 2002, whatever I get thereafter, kindly give me, whatever I got was already taken back.
Hmm.
And that much only I have been given now, my lord.
So let's hear it on merits.
Lordship,
All right.
lordship.
The, should we proceed today itself or decide this preliminary objection first? What do you
My
want?
lord, preliminary objection, I'm not very much, my lord will have the it on merits.
All right.
May I request that if it can be taken up, my lord, on the 15th, my lord, I was prepared, my lord, to address arguments on the locus.
This is
issue.
not fair, Mr. Bhukan.
My lord, I expected, my lord,
You have been
something-
coming to the court, this court, I think for the last 2 months.
My lord, I
You should
expect-
know that we don't really
My lord,
go on these ceremonies of preliminary objections and everything. Argue on substance,
I bow down, my lord.
plain and simple.
Because there are some judgments also, my lord, which I would like to cite, my lord. I'll prepare a compilation and have it ready, my lord, on the next day. My lord.
All right. Though the respondents have filed preliminary objection for the locus of the appellant association to file the instant writ appeal, then counsel Mr. Nair, senior counsel Mr. Nair, frankly concedes that rather than pressing the said preliminary objection, his client would be better advised to have the appeal decided on merits. Mr. Fukan, representing the appellant, prays for time to thus the preliminary objection is overruled. The appeal will listed on
I request for 15th of June.
either 14th or 16th.
Well, 16th then.
16th.
Deeply obliged.
On the first blush, manner, it looks to be a very.
He was, at that point
He
of
got
time, he had his own influence.
My lord, he got it, what he had to go, he had from there, he came down here.
It deserves nothing else.
He got it.
Does it deserves
But
nothing
once
else?
having got that punishment, my lord, they should not punish him again. No, that's the only thing.
We brought him down. He went too fast. We brought him.
Yes.
Lordship, I have received instruction, Lordship, already.
Yes. Yes, please.
Last occasion, Lordship, I was directed to take instruction from SP Sibsagar, Lordship.
Yes.
Already, Salan has been deposited, money has been deposited. SP has directed Gorisagar PS to provide them police.
Why is the bank made to run from pillar to post for this purpose? Why this approach of the police authority? Can you tell us, please?
That has not explained, Lordship, but I talked with SP and he provided.
Money has been deposited. How long will you take to complete the exercise?
Lordship, they will say the convenient date, Lordship.
We are ready at any point of time, only that they may give us a date so that.
Lordship, they may approach the Gorisagar police with the date, they will provide, Lordship.
The money has been deposited.
Yes, your lordship, on 11.
The amount
23.
the Learned Counsel MS Bora submits that the fee for providing, charges for providing police aid have already been accepted by the SP Sibsagar.
Yes.
In the SP office Sibsagar, and that now the process for handing over possession of the premises in question to the petitioner can be expedited. And Counsel Mr. What's your good name, sir?
M. Sharma, your
M. Sharma, representing the respondent bank, submits praise that 15 days time may be granted so that this process can be completed. List on,
Lordship, they have to approach Gorisagar police.
they will do. The bank shall ensure that the proceedings are now expedited and possession of the premises in question is provided to the petitioner as per his entitlement within next 15 days. List on 19th June. Much obliged.
May it please the lordship. My lord, where by the impugned judgment, my lord, the promotion as well as upgradation of the appellants has been interfered with. I may first take your lordship with the facts.
So 16/5, this court was apprised that the proceedings had been completed.
Yes,
Regarding what?
The promotion exercise in pursuance to the directions
Of the
that is single
single
judge.
that, but they were supposed to produce in a seal cover.
They must be having it.
No, they have already done it. Only thing is, my lord, lordship did not open it because lordship was inclined to hear the matter.
Yes, very well. Please start.
Now, my lord, what had happened? If your lordship would first come to page number 247, my lord. This is how it all started. 247. This is the minutes of the 75th board meeting held on 19th of June 2001. My lord will kindly come to page 251. Upgradation of the post of junior engineer to assistant engineer as per the Central Pollution Control Board norm. The member secretary apprised the board that as per Central Pollution Control Board, no diploma engineers should be recruited, and existing diploma engineer should be upgraded from the post of junior engineer to the assistant engineer, aiming at increasing efficiency of the engineering services of the board in future. The Central Pollution Control Board also desired that state boards to follow the said policy. The matter was discussed. The board agreed to the policy in principle. But considering the present financial position of the board, it is resolved to upgrade those posts of junior engineer which have confirm eligibility of the norms phase-wise.
Yes.
Board will not fill the present vacant post of assistant engineer till it is decided by the board otherwise. The member secretary of the board will submit service sheet of the upgraded engineers person-wise, specifically mentioning the period of qualifying service, the scale of pay, the basic pay, departmental proceeding, if any, of the junior engineer for final approval of the board. So, my lord, pursuant to this decision, my lord, in fact, the appellants before lordship, their services were upgraded, my lord, by an order at page 147, my lord.
Yes.
Under section 22E, actually it should be rule, my lord, of this so rule 77 as amended. The 14 junior engineer of this board having experience of more than 10 years of the service are upgraded to the post of assistant engineer with immediate effect. Kindly see, my lord, this was done way back in 30th December 2005. Subsequently, my lord, they have been encadred also. They were, my lord, they were shown in the, the gradation list. Nobody objected, my lord. Now, after this, my lord, they took a decision on, my lord, page number 141, my lord. This is another board meeting. This is 102nd board meeting of the Pollution Control Board held on 9th of December 2019. My lord will kindly come to page 142.
Yes.
Agenda item number 3, somewhere in the middle, proposal for upgradation of the following post, amongst others, my lord, from assistant engineer to the post of assistant executive engineer, that is C. Then my lord will kindly come to C towards the bottom. From assistant engineer to assistant executive engineer, 10 years of minimum total service as assistant engineer in the board. After thorough deliberation, 13 number of post of assistant executive engineer may be upgraded to the executive engineer. 2 number of assistant executive environmental scientist may be upgraded to executive environmental scientist. And we are concerned, and 5 number of assistant engineer may be upgraded to the assistant executive engineer, keeping the cadre strength at 264, number as revised on 2013-14. These upgraded posts will automatically come to the original cadre upon retirement, termination, resignation of the above mentioned post. The board member has agreed to upgrade this post under section 4(3) of chapter 2 of the PCBA Employee Service Regulation. However, an intimation may be sent to the government. Well, the decision was taken in principle. However, the actual order was passed on, my lord, page number 116. 9th of October 2020, my lord. In pursuance to the decision taken in 102nd board meeting held on 9th of December 2019 under agenda item number 3 and as per approval of the Environment and Forest Department, Government of Assam, white dated 13th of July 2020, the following assistant engineers are allowed to hold the upgraded post of assistant executive engineer with effect from the date of joining in their original place. The pay and other promotional benefits will accrue to them with effect from the date of their joining. So, my lord, they are appellant number 6 to 10. They are in the batch of, my lord, upgraded assistant executive engineer. Then, my lord, in the meantime, a promotion exercise was also undertaken, my lord. And pursuant to that, at page number 109, this is the, my lord, minutes of the selection committee meeting held on 15/9/2020. Towards the bottom, my lord, promotion of assistant engineer to assistant executive engineer. There are 3 vacant posts in the cadre of assistant executive engineer and 3 resultant vacant posts of assistant executive engineer will occur consequent upon promotion of assistant executive engineer to executive engineer. This 6 number of posts are to be filled up by promotion from immediate lower cadre, that is assistant engineer, as per the Pollution Control Board, Assam Employees Service Regulation 2014. Then next page, my lord. Kindly come to this second subpara. After considering the educational qualification, experience in ACRs, the committee recommends the promotion of the following assistant engineer to the rank of assistant executive engineer for promotion the 12th and 17 respectively. So, my lord, appellant number, serial number 1 is appellant number 1, serial number 2 is appellant number 2, and similarly, my lord, the down below 1, 2, and 3 are appellants number 3, 4, and 5. Now, my lord, what had happened? The writ petitioner, my lord, who instituted the writ petition, he is a direct recruit, my lord, and he was recruited in the year 2012. We were, my lord, upgraded in the year 2005. In the meantime, we are encadered. And my lord will kindly come to page number.
Date of encadrement.
My lord.
What is the date of your?
Yes, I'm coming to that, my lord. My lord will kindly come to page 92.
Yes.
In fact, at page 90, my lord, gather list of officers and staff of the Pollution Control Board Assam as on 1/2/2020.
There should be some order of
I am
encadrement.
coming, my lord. Yes.
Let's see that.
Yes, yes. My lord will kindly come to page number 22. 92, sorry, my lord.
Yes.
Gather list of assistant engineer AE. Dhiren Sharma, appellant number 1. So, 2, my lord, serial number 10 are the appellants, and serial number 2 is the writ petitioner. Kindly see, my lord, his entry into service 1/8/2012. Now, lordship's query. Page 149, my lord. On the 5th of December 2009, pay of the following assistant engineers of the Pollution Control Board were upgraded along with the post by order dated 30th December so-and-so are hereby fixed their pay as per provisions of FR so-and-so as shown in their name against so-and-so. My lord, we have filed an additional affidavit the other day, my lord. Yes. My lord will kindly take the affidavit which we have filed, my lord. It starts at page 287.
Yes.
Yes. Page 298 is the order whereby they were upgraded, my lord. Then, my lord, the board sought approval of the government, my lord. That is at page 299. With reference to the above, I'd like to say that as per resolution of the 74th board meeting of junior engineer along with incumbent upgraded to the post of assistant engineer by office order dated 30th of December 2005. As per provision of the Fiscal Responsibility and Budget Management Act 2005, government approval for the purpose is necessary. I therefore request you to kindly accord government approval for upgradation of the post along with the incumbents at an early date. In this connection, it may also be pointed out here that upgrading assistant engineers have already completed more than 3 years of their service as assistant engineers without financial benefit. A photocopy of this so and so. The next page, my lord. The inter-C seniority of the following assistant engineer diploma holder of the pollution board Assam are hereby fixed provisionally as shown below against their name. Objections, if any, may be submitted to the undersigned. My lord, serial number 17 to 27 are the appellants number 1 to 10, my lord. Then, my lord, the draft list was published. And finally, my lord, at page 300, sorry, this is not 300, my lord. Notification date. My lord will kindly come to page 307. In fact, my lord, it starts at 303. 7th of January 2013. The draft civil list engineering cadre of the pollution board Assam was circulated by this office letter dated 9/11/12 amongst all the engineers for pointing out omission, commission and authentication by each member. The objections received were properly examined and corrections made after verification from record. The draft civil list as finalized is published for information of all. My lord will kindly come to page number 307. Now, serial number 41 to my lord 51 are the appellants, and serial number 53 there has been construed to be the date, my lord, when they were upgraded. Then, my lord, then at page 309, the cadre list of officers as on 1/8/2015 was published, wherein at page 311, my lord, the name of the appellants appear at serial number 3 to serial number 12, and that of writ petitioner at serial number 14. Similarly, my lord,
This is where
311, my lord.
11. Yes.
Serial number 3 to 12 are
Yes.
the appellants, and serial number 14 is the writ petitioner.
Yes.
Then, my lord, finally, as on 4th of February 2020, another notification was published, and the relevant portion is at page 317. Serial number 1 to 10 are the appellants. Serial number 12 is the, my lord, writ petition.
Yes.
Now, my lord, it is a fact there is a distinction between promotion and upgradation. That is not our argument that there is no distinction. Now, my lord, first question which I would like to argue is how the writ petitioner was aggrieved, my lord. I'll say, my lord, because, my lord, promotion up to the grade of executive engineer is by time scale. That means seniority. Unless somebody is unfit, everybody will be promoted. So how is prejudice? He's just serial number 12. He will have an enforceable right when, my lord, people junior to him are promoted to the time scale. He was never, my lord, he had no, he was not even in the zone also, my lord. So therefore, he cannot be an aggrieved person. Now, my lord, lordship knows in the service jurisprudence what we find from different judgments of the Supreme Court. At times when, my lord, the beneficiaries are not to be blamed, and many a time Supreme Court has never interfered, my lord. For example, this exercise. Strictly, it may not be in accordance with the rules, but then, my lord, we had no hand in it. For administrative exigencies of the board, actions were taken. And my lord, most importantly, our upgradation was never put to challenge. The gradation lists were never put to challenge. Now, at this stage, my lord, whether it could have been done. For that, my lord will kindly take the regulation of the board, my lord. Regulation.
Is it available on the call?
My lord, that blue, I think on last occasion, yes. My lord will kindly come to regulation 4 at page number 3. Services of the board shall comprise the categories of post as mentioned in table 1. Board may include any other category of post or post under the service of the board or exclude from the post listed in table 1 as and when felt necessary for smooth functioning of the board and in the public interest temporarily for a period not exceeding 2 years by the board's decision and on permanent basis with the due approval from the government of Assam. Members of the cadre shall have no claim for appointment to any cadre except in accordance with the provisions made in this regulation. Now, 3 is important, my lord. The board may by resolution may upgrade or downgrade posts within the sanctioned strength. However, any addition to the existing strength of the cadre shall be with the approval of the government. My lord, with all respect, I'll submit, my lord. Regulation 4.3 empowers the board to upgrade or downgrade any post within the sanctioned strength. And in case, my lord, it results in, my lord, exceeding the sanctioned strength, then it can be done with the approval of the government. Approval does not mean prior approval, it could be post facto also. Then, my lord, will kindly come to regulation 7. 7. Appointment to the service under the board shall be made by the appointing authority by any one or more of the following methods: by direct recruitment, promotion, on deputation, on compassionate ground, on contract. Of course, my lord, here upgradation is not included. But my lord, in my humble submission, my lord, that has to be called out from the harmonious reading of the rules. 4 is important. The number of vacancies under various cadres and their percentage for direct recruitment and for promotion from next cadre shall be decided by the board authority. So, my lord, what would be the number of vacancies under various cadres and what would be the percentage as per direct recruitment or promotion? These will all be decided by the board in a meeting. Then, my lord, will kindly come to, my lord, regulation 9. Recruitment and promotion. Subject to suitability as may be decided by the selection committee and by the appointing authority as set forth in regulation 10, and also subject to possessing such qualification and experience as prescribed under table 2 to 7 in appendix 2 to 7 under regulation 7.4, appointment by direct recruitment or promotion to the following categories of posts shall be made by the appointing authority on the basis of the select list prepared by selection committee referred to in regulation 14. Now, my lord, may kindly come to Roman 2, my lord. Qualification the required qualification would be bachelor's degree in engineering, that is BE, BTech or BSc in engineering, in chemical, civil, environmental from any recognized Indian or foreign university, or AMIE of Institution of Engineers India Limited. The educational qualification and experience for the posts under the service shall be as per table B. Now, this is very important for the present case, my lord. Promotion from the level of assistant engineer to assistant executive engineer and then to executive engineer shall be on time scale basis, subject to availability of post and suitability of the persons as considered by the selection committee. So, my lord, up to grade of executive engineer, the criteria is seniority cum merit. Then C, promotion from the level of executive engineer to superintending engineer and above, that is so and so, shall be by selection. That means, my lord, executive engineer and above, the criteria of promotion is selection. Therefore, it's pure merit. There, my lord, question of one who is in zone of consideration, if he is not considered, then it will be a right, it will be a violation. Then, my lord, will kindly come to regulation 49, my lord. At page 31, there's the provision for relaxation, where the board is satisfied that the operation of any conditions under this regulation causes undue hardship in a particular case, the board may order or to dispense with or relax the requirement of the regulation to such an extent and subject to such condition as the board may consider fit and proper for dealing with the case in a just and equitable manner by board resolution, provided that the case of any person shall not be dealt with under this regulation in any manner less favorable to him, and that provided by any of this regulation. Then, my lord, next phase, this is most important, my lord, table 1. Here, my lord, kindly see the cadre strength. Serial number 5, assistant executive engineer cadre strength is 18, assistant engineer cadre strength is 30. So whatever has been done within the cadre strength, my lord. In other words, my lord, the post which has been upgraded, which has been encadred. Now, my lord, the basic case of the petitioner before the learned single judge was that we do not have BE or BTech. Now, that is where, my lord, this is where my answer lies, my lord. Kindly come to the appendix 2, my lord, serial number 4.
Yes.
For existing promotee engineers, the qualification shall be relaxed to diploma in engineering. Similarly, at serial number 5, for assistant executive engineer also, my lord, the same yardstick has been prescribed. So, my lord, my humble understanding, my humble submission is, my lord, this regulation has to be interpreted to include upgradation also, my lord, in this particular remark column, so as to make the rule, my lord, workable. And the fact of the matter is, pursuant to the decision of the Central Pollution Control Board, State Board, my lord, took a decision. We are upgraded, we are encadred. Now, once we are encadred, my lord, we lose our previous entity. Now, we have to be treated as a person who is comprised in the feeder cadre for promotion to the grade. Promotion or upgradation, both are permitted under the rules. So, that being the position, my lord, to say that because we didn't have BE, therefore, my lord, our promotions were interfered with, that may not be a very correct approach. My lord, there is no dispute that we are encadred. There is no challenge to that. Therefore, my lord, this upgradation has to be, my lord, construed as if, my lord, our whatever was, my lord, requirement was, that has been relaxed by invoking power under 49. My lord, lordship knows that Supreme Court decision in that Purnomi Oil Mills case, if there is a power of relaxation, even if, my lord, that relaxation power is not indicated, it will be presumed that the power was exercised pursuant to that enabling power. And lordship knows two other judgments, my lord. One was that G.S. Lamba and Narendra Chadha. In fact, I'll place that Narendra Chadha judgment, my lord. My lord, may kindly have 1986 2 SCC 157. List one, yes. 1986. 2 SCC 157. বাকি কেইখন কিতাপ ওলাই থব কৈছে নে এইখন দি দে দেৰি লাগিব নেক্সট পেজটো দিবি 1990 My lord may kindly come to page 171, para 16, my lord, where a similar rule 16 in this particular case is quoted. Whether Honorable Justice Chaudhary has got it, my lord. Page, yes. Government may, in consultation with commission and for reasons to be recorded in writing, relax any of the provisions of these rules with respect to any class or category of person or post, and no such relaxation shall be given so as to have retrospective effect. G.S. Lamba's case may be carefully considered at this stage. In that case, this court was concerned with Indian Foreign Service, which was governed by Indian Foreign Service Branch B Recruitment, Cadre and Seniority Promotion Rule 1964. The said rules provided for recruitment to the said service from 3 different services: direct recruitment by competitive examination, substantive appointment of persons included in the select list promoted on the basis of limited competitive examination, and promotion on the basis of seniority. One of the rules provided that recruitment should be made from the above sources on the following basis: 1/6 of the substantive vacancies to be filled in by direct recruitment, 33 1/3 of the remaining 5/6 of the vacancies to be filled up on the basis of result of limited competitive examination, and remaining vacancies to be filled up in by a promotion on the basis of seniority. The court found that the direct recruitment had not been made for years, limited competitive examination had also not been held for years, and promotion from the select list had been made in excess of the quota. It found that there was enormous departure from the rules of recruitment in making appointment over several years. The court was of the view that the situation in this case was similar to the situation in 2 other earlier cases of this court in Janardhan and O.P. Singla. The court felt that in the circumstances, it should be presumed that excess appointment by promotion had been made in relaxation of the rules, since there was power to relax the rules, similar to the power under Rule 16 in the rules with which we are concerned here. Justifying the above view, the court observed that so and so. It was, however, contended that it is not permissible to infer that promotion in excess of quota were given by relaxing the quota rule, because posts of integrated grade 2 and grade 3 were within the purview of the Union Public Service Commission, and proviso to Rule 29A mandates that power to relax is hedged in with a condition that it can be done after consultation with the commission, and there is nothing to show that commission was ever consulted. Undoubtedly, the proviso to Rule 29A requires that controlling authority cannot relax any of the provisions of the rule in respect of the post with which we are within the purview of the Union Public Commission, unless after consultation with the commission. It was submitted that nothing is placed on record by the petitioners to show that power to relax the quota rule was exercised after consultation with the Union Public Service Commission. Assuming that there was no consultation, would the exercise of power to relax be vitiated and the appointments in relaxation of the mandatory rule would be void ab initio invalid, would be ab initio invalid? Commencing from the decision of the Privy Council in so-and-so, when provision of a statute relate to the performance of a public duty, and the case is such that to hold null and void acts done in neglect of this duty would work serious general inconvenience or injustice to the person who have no control over those entrusted with the duty, and at the same time would not promote the main object of the legislature, it has been the practice to hold such provision be directory only, neglect of them though punishable, not affecting the validity of the acts done. This is what I was indicating, my lord. When the beneficiaries are not to be blamed for it. The view was expressed in the context of failure to revised the list of jurors by the staff sheriff according to the revised statutes of Quebec, and conviction was challenged on the ground of mistrial held by selecting juror from unrevised list. The challenge failed. Coming home in the state of so-and-so, a constitution bench of this court specifically held that where consultation with the Public Service Commission is provided as required by Article 323C of the Constitution, such provision is not mandatory and they do not confer any right on public servant, so that absence of consultation or irregularity in consultation does not afford him a cause of action in a court of law. There are number of subsequent decisions to which our attention was called, reiterating the same principle. They're assuming there was failure to consult Public Service Commission before exercising the power to relax the mandatory quota rule, and further assuming that the posts in the integrated grade 2 and 3 were within the purview of the Union Public Service Commission, and acceptance for the time being that commission was not consulted before the power to relax the rule was exercised. Yet the action taken would not be vitiated, nor would it furnish.
Chaudhary, we are not undertaking final hearing, we presume.
My lord.
We are not undertaking final hearing, we presume.
Oh, yes. I'm sorry, I thought my lord, that's just taking up for the.
My lord, if not undertaking the final, I was under the impression that the matter would be finally heard. My lord, that seal cover can be taken because I am now, my lord, not being promoted. I am kept back there. There are orders of this honorable court still not coming. So if that seal cover can be opened, my lord, then if I'm through, my lord, at least I can be promoted subject to, my lord, the final
Their
outcome.
position in the Senate.
No, he's
No,
just below us, my lord.
Okay.
No, my case before the honorable single judges, neither can they be promoted, nor they upgradation, my lord, it's out of the way. It cannot be done. But we were qualified people who were there.
Right.
So by considering these people, the
Presently, they are holding the post of executive
because
engineer
of, my lord, the interim orders passed by my lord.
in this in this case.
In this case,
So there are posts available for your promotion. There is a post available.
there are posts, extra posts also available.
My
That
lord,
also not considered.
If he's promoted, my lord, I've got nothing to say.
All right, then
Only
the
thing is
academics,
subject to outcome.
of course,
But my lord, that promotion would be, my lord, again subject to the
Of
final.
course, of course,
of course, then the issue would be of seniority
eventually.
or whether they are entitled to be promoted or not. That's a secondary exercise to be
Because
done.
my lord, one aspect here, my lord, which my lord will know, there is a person, my lord, who was promoted on the reservation. He is below me. I did not challenge his promotion because he was a B, he was a party, my lord, but I made a statement that I'm not challenging because he is a B and my lord, he is under the reserve community, so I have nothing to say against him. So these promotions, ultimately, Honorable Supreme Single Judge has also said, has to relate back to that date.
For the time,
I'm happy
for the
with my
timing,
promotion. I'm happy. with
your client's issues will be resolved.
Lordship.
Because then the issue of seniority
Eventually.
and whether they are entitled to be promoted, that's another exercise we'll undertake there later. All right. They let the seal cover be opened.
Yes, my.
My lord can have it, whatever it say, my lord, I don't know.
Is জগৎ দেখা না?
হ্যাঁ।
নামটা আছে না না? ইয়াতে লিস্ট
ইয়াতে নাজানো
না জানো এটা কি কৰা নাই তন্ত present management is not
প্রেজেন্ট ম্যানেজমেন্ট ইজ ইউ অন বোর্ড ম্যানেজমেন্ট ইজ ইউ না না ইন্টারিম অফিসার তো নিদিলা
না উল্টা করবে
প্রেজেন্ট ম্যানেজমেন্ট
তার লগত না ওই আমার ক্লায়েন্টের উল্টা করে আমার ক্লায়েন্টের উল্টা করে
All right, you can have a look at it. 5 have been promoted because against the 5 number of vacant sanction posts.
My lord, we'll just allow it.
You can have a look at it. Yes.
My lord, I hope they have done it in terms of the orders of the Honorable Single Judge.
Just have a look at it.
দেখাটো বহুত দেখাটো বোধে সেইটো আছে 2 নম্বৰ আছে
My lord, the direction of this honorable court was that you will comply with the Honorable Single Judge's judge. This board, my lord, from the word go, has been acting against their regulation. This is a bogus exercise they have done, my lord. I'm getting a promotion, I have no objection.
You are
But
placed
this
at
is
number
not the
2.
compliance of the honorable single judges. order.
Why?
Because the single judge's order, my lord, they were in altogether 11 posts.
Hmm.
11 posts interfered with. They were protected.
Hmm.
But
In-
interfered
In
with.
addition there to 11.
In addition to this, there are 11 posts. my lord.
Why you are bothered about the remaining?
Because my lord,
It's
the
not a
direction of the
public
honorable
interest
single judge,
litigation.
because my lord, tomorrow, I may be, if I accept, my lord will protect me, that's a different thing. But they are conducting this exercise in pursuance to the honorable single judge's order. There was no stay on that.
Right, but you are being promoted. What is the problem now?
I have nothing, but my lord will not give a seal of approval to this one. I've
We
been
will
promoted
say,
from
we
this.
will
I've no-
simply say that the respondent writ petitioner has been promoted, that's all.
And
Will be promoted now, they're not
Will
been
be
promoted.
promoted.
But my lord, this is not, my lord will record that this is not in terms of the honorable single judge.
That is your
No, no,
contention.
that
You
is
will
a
file your
very
objections.
independent case.
We can't record that. We don't have
Because my lord will
any
see.
material to doubt the veracity of this one.
My lord,
Right now.
my lord did not. Only thing, my lord will see. The appellants, how many are there, my lord? My lord will only have, there are 10 appellants.
Mm.
So, my lord, 10 promotion orders were interfered with. There will be 10 vacant posts, my lord.
But those, we have protected them
No.
for the time
There is
being.
an order, my lord, that they will not be disturbed, but the
So
promotion
without
exercise will be
disturbing
carried
them,
out.
how can more people be promoted on those posts which they are holding?
My lord, my
They
lord,
have done this exercise against available vacant
my
posts.
lord, what had happened here was after the honorable single judge's order, their promotions, they were reverted.
That
This honorable court
we have
protected them.
protected. So that reversion has not come into force.
No.
How could they make exercise of promotion on those posts
Fine,
for the present?
fine, my lord. I am promoted, I'm happy, my lord.
The sealed envelope has been opened. A perusal of the minutes of the selection committee would reveal that 5 assistant engineers, including the respondent
Two, Jagat Deka, my lord.
Jain Deka,
Jagat Deka.
Jagat Deka
Seven.
have been recommended for being promoted from the post of assistant engineer to
Assistant.
rank of assistant engineer to assistant executive engineer. The minutes are taken on record and shall be acted upon in the terms indicated.
And everything will be subject to outcome of this.
The final, the exercise of promotion made by the selection committee shall remain subject to the outcome of this writ appeal. The writ appeal is admitted. The respondents are duly represented. List for hearing.
Deep privilege.
Copy of the minute shall be provided to learned counsel representing the parties.
Original name. Original name.
This is the original.
It's the original.
Photostat copy of the minute shall be kept on record and the original shall be returned to learned counsel representing the board. Copies shall also be provided to learned counsel representing the parties.
My lord, can I make one observation, my lord? Because my lord has given me a permission from this. My lord, my seniority would be subject to outcome
Of
of the
course.
writ appeal. That much, my lord.
The entire,
Because tomorrow, my lord.
the claim of the respondent for seniority shall also be subject to the final outcome of
Much of
this writ appeal. This, what are the two interlocutory applications?
My lord, one is filed by me for this order that can be closed, my lord.
Interlocutory application number, civil number 925. What is your application?
We filed for a subsequent senior, that order is there, my lord, can be closed.
Closed, both of them.
Are closed. Both
Earlier
the
interim
IEs
order will continue till disposal of the appeal.
that we already. The interim protection granted to the petitioners, appellant shall
Continue.
remain in currency till disposal of the appeal. It is further directed that claim of the respondent number 2, respondent Jagat Deka for seniority shall also be subject to outcome of this appeal.
Deeply.
My lord, maybe in sometime in June last, if not
August.
August. Fine.
List for hearing. Take them. Fresh ones.
Before my respected senior, my lord, starts with the marriage. But only one thing I'd like to point out of curiosity. Lord, in the read appeal, fresh respondents are included.
Were not in the, not in the writ petition.
Not in the read petition, respond number 5, 6, and 7. So normally when we file read appeal, we seek a leave.
Permission to leave to
Leave.
implement additional
That
respondent.
leave is not there. That is out of curiosity, I'm saying, my lord, also may consider as objection or may not. They were never completed.
But my learned friend has raised, of course, otherwise it's correct. But my instruction is, Lordship will kindly see. I don't know whether my friend was there in before the learned civil judge. This application was filed for implement of those respondents there. And
Whether
that
it was accepted, sir.
that was taken into consideration by the learned single. It is recorded. at
Let us
page
see the
190
order. It must be there in the order. then.
197 page. Lordship will kindly come. 197, last paragraph, 23.
Oh, the array of parties must be there in the order also.
Yes.
In the order, the array of parties does not indicate.
Paying for implement of so and so, so and so, so and so. Who participated in the interview on Iman? 48 post of associate doctor in the department.
Prayer is there, but whether the
In the
application was
present
accepted.
proceeding Has been heard together with this petition. So that was the procedure followed by
They were
the,
never put to notice, we suppose.
ought to have been. That was the procedure that I should have been disposed of first. But the learned single judge took up this petition heard together and as if that was been allowed. Whether, but then I don't think those private respondents were present before the learned.
They were not put to notice.
There's not.
How could they have been?
That is in my lord, my submission irregularity.
But then you will have to seek leave, sir, as your application was never
That
formally
was
allowed.
Already there. That application was already there, learned single judge. specifically
Samantha,
without passing
Those persons were never put to notice.
No, right.
So
That is why.
that application was never accepted, as a matter of fact.
That also, my lord, my
Because if that application had been accepted,
the language shown by. So,
understood, sir, the array of parties in the order.
My lord, because this procedural aspect has to be put at right. That I agree. That I agree.
Just file a formal
I'll file
application,
it.
we'll allow it.
That would be, until then, Lordship will consider minus this. Lordship will not take into account for the time being, their presence. But here, what happened, the issue relates to appointment, selection and appointment to the post of associate professor in the Department of Business Management of the Guwahati University.
Yes.
The question ultimately boiled down to whether I am qualified. I was one of the applicants.
Hmm.
Whether I am qualified to appear in the selection process.
On the basis of the publications which were not originally submitted.
Exactly. Now, thereafter, what happened, my lord? On the basis of an order of the learned single judge, I submitted all the application. That was permitted. And learned single judge also directed at the prayer of the university that before I am allowed to participate in the selection process, my application should be evaluated by the internal quality assessment cell, IQAC they call it. And if ultimately approval comes from the IQAC, that cell, then only I can be allowed to participate in the selection process, that is interview. Therefore, the learned single judge allowed them, all right, you take the opinion. And the opinion came ultimately, they filed an affidavit saying that I won't fulfill the requirements because my score in that research papers and those part, it falls short of 75. So I am not eligible to appear before the selection committee. That was questioned by us by filing an additional affidavit to that, that no, I have submitted all this, my conditions are all there. During the midst of hearing, the copy was produced, that report was produced, and we have also raised the objections there already. But the learned single judge came to the conclusion, since the report has come that my score falls short of 75, it is 61 or 62 point something.
Please read the para 11. It says it was found that the petitioner failed to satisfy one of the basic conditions to be eligible as an associate professor, as his papers are not peer reviewed and non-existent.
Yeah, exactly. That is what.
Then there is one more question, sir. Question is that if this indulgence was given to your client
Yeah.
to file the publications which were not submitted online, this had to be an exception, a relaxation to all candidates. Could not have been given to one man only.
Well,
That was violating Article 16.
that was the, of course, point also raised on behalf of the university. But the learned single judge thought it
Yes.
proper that concession he deserves because of the situation that time, the COVID.
If at all that
Situation
concession was to
there.
be granted, that had to be granted
Well,
across the board.
Well, Lottie may also look into it from the other angle.
Yes.
None other than me asked for submission of additional.
Asking
All have
means
done
what?
it.
Asking means what? Issue is that no one could comprehend that the university will be granting this relaxation.
No.
Why could one anticipate?
True. Therefore, well, factually also, my
Yes.
submission factually also, no other than me asked for. But I could not submit all the documents that.
It's a fact.
Correct.
And the
And I
advertisement
submitted
clearly
it.
said that minimum of seven such research papers had to be submitted.
I submitted 6.
Yes, so one was lacking.
What
You
was
would
that?
not have qualified under
So
the order of
with
this
that,
court.
with that, of course, I'm not. With that, I could not have. Therefore, I prayed before the authority.
This is basically the law as laid down by Supreme Court, that whatever is to be filed has to be filed by the last date of submission of the application form. Subsequently filed documents to cover up for the shortcomings will not be accepted, sir.
Well,
That is what the law is.
principle is rules of the game cannot be changed.
That is not
I-
even
I-
changing the rule. That is
do
not changing the rule.
I do not
Basically,
have any
the concept
question of
is
prejudice
the application should be complete in all
in all
aspects,
form, in all aspects.
on all aspects. That's it,
Malad, I don't have any dispute on that,
sir.
but I prayed for allowing me to submit. Authority rejected. The honorable court, this honorable court granted. Therefore, that aspect was sealed in the sense that they didn't raise any objection against that. That was never put to challenge, that could not have been done.
So here the
immediately
question, when the red court goes into the matter, the issue of Article 16 comes into picture. That if this relaxation is given to one, why
Malad,
not to all? And whether the relaxation at all could have been given.
Malad,
Second question is,
Malad, that issue, of course, it was very relevant at one point of time, but not now in my submission.
all right, sir, very well.
Not now, because that has been gone. They have waived it. It would be treated as they have waived it. And ultimately, I have been.
They have no authority to
papers were
waive.
taken into account.
They have no authority to waive.
Malad, but then
That action of waiver,
this,
even under the orders of this court, is
Malad,
arbitrary.
Malad, my full submission is
Yes, please.
waived in the sense they waived the right to come on appeal before against them.
That
That is
we
what I mean, Malad.
that we
That is
understand.
what I mean, because they didn't allow me initially,
Yes,
but this honorable court allowed me.
yes.
And they didn't come against that order. So
That is, respond number 4 has raised this objection in the red court. Read,
Malad,
sir.
he also,
Para 20.
Malad, he also didn't come challenging that order. The learned single judge has also indicated that order didn't challenge. That order
That
was.
is an interim order subject to final outcome of the appeal, sir. That's simply an interim order. So your consideration on the basis of some concession given by this court,
Yeah.
which is contrary to the law as laid down by the Supreme Court,
Malad,
what is it worth for? Let us
Malad,
know.
Malad, my only answer
Yes,
to
please.
your lordship's query would be that since the other side has not raised any question to that, lordship may not enter in.
An action which is totally contrary to the law of the land, can it be given in premature because it was granted under an interim order of the court?
Malad, but then this attains the character of a final order since it has proceeded thereafter also with the approval of the
All
court,
right, sir. All right.
with the approval of the court.
Yes.
That is why I say, Malad, Otherwise,
Anyway,
yes,
all right,
I would
your
have- I-
argument will take note of, sir.
yes, my lord, I
Yes.
would have been out at an earlier stage. Or it could have been taken to a logical end that time, that
Yeah.
question,
Yes,
that was never taken to that extent. Therefore, I say,
all right,
then lordships may not go to that aspect
very
now.
well, very well. Please.
Now then the question is, my lord, the learned single judge kindly come to the relevant paragraphs. Hmm? That at page 201 relevant paragraphs are there. Before I take your lordships to those paragraphs, let me just place the law. IQAC report is required and there is a set of rules which provides for how to assess those documents, those resource papers and all, and how to evaluate those by giving appropriate marks to every paper. That is there. That is there. But this report which was submitted before the learned single judge, this apparently shows that all these criteria were not taken into account. And therefore, I was not properly evaluated. My papers were not properly evaluated. That is my basic case.
Okay, sir.
They say that I have secured only 71, 61 or something, 61.5 on the basis of my research papers. But there are not only research papers, there are other papers also which I submitted. And those ought to have been taken into account as per the rules. Single judge has gone into, since the IQAC report says that you are not qualified, you are not qualified. That much. But the report when placed before the authority, I mean this honorable court ought to have seen it, whether that conforms to the legal requirement. It was done in accordance with the rules. If it is not,
Sir, now if you are on that, please read that interim order.
in
Does it give you a right of consideration of those publications? That interim order you are relying upon, please. Come to page 12,
here also,
para 45, it is reproduced. It is saying you all right, you present them. It doesn't bind the university to consider them.
right, my,
Please read
now,
that.
para,
That they will be accounted for evaluation.
yes.
There is no such direction, please. Read, please.
At page 2202, my lord.
Yes, para 45.
Paragraph 45,
Yes.
4th August 2022. At so and so. Mr. So and so, learned standing counsel for the Guwahati University submits that no interview for petitioner or petitioner could be conducted as he came late on the date of interview. However, he submits that before the interview is held, with regard to the petitioner, the Guwahati University may be permitted to evaluate the research score of 75 as per the criteria given in Appendix 2, Table 2 of UGC regulation. He also submits that the Guwahati University has no objection with regard to the petitioner submitting the remaining journal papers in terms of the advertisement.
Yes.
After hearing the parties, the Guwahati University authority is permitted to evaluate the research score of 75 as per the criteria given in Appendix 2, Table 2 of UGC regulation and file a report before this court. In the meantime, the petitioner is also permitted to submit the remaining journal which he could not while making his application against the advertisement.
So where is the direction that these papers will be taken into account, sir?
Well, that for evaluation. They
The
said that-
direction is only to evaluate the criterion as per appendix 2, table 2 of UGC regulation. That regulation is reproduced
Well, here,
earlier,
here,
which
the-
says 7 journals. So there was no direction to consider these
no, but
later filed publications.
before that, Lordship may also kindly see at page 193,
Yes, please.
paragraph 7.
Yes.
That was the first interim order,
Para
7
7.
of the impugned judgment,
Yes, yes,
193, my lord. Lordship got it?
yes.
Yes. 7, by order dated 29/7/2022.
That is the
court directed
liberty granted to appear in interview.
what
Yes.
is- to allow the petitioner to appear in the interview for the said post of assistant professor business session, so and so, with the observation that if the interview is over, by the time concerned authorities may the university receives the order, then the said university shall take necessary and make an arrangement to interview the petitioner on a later date.
I know. I'm dealing with that. Yes,
So that direction was already there.
direction to
But
allow the petitioner to participate in the interview.
yeah, that
Where
was
is the
there.
direction that the papers, publications which are submitted later shall also be taken into account for
Malad,
this evaluation process, please?
Malad, my understanding would be like this.
Yes,
And
please.
explicit, my lord. Since I was allowed to participate.
Yeah, yes,
then
all
they
right.
Came.
You file the papers to consider it or not.
Now.
That is as
now
per rules.
For them to consider, then they came. They came before the honorable court and said that, well, he has been asked to participate, but before that we have to evaluate it. Only then he may go for.
So evaluation would have to be done of
Right.
what was presented along with the application.
Yes.
Nothing beyond that.
So therefore, when the learned singers allowed us to submit it and allowed them to evaluate it. And accordingly they evaluate.
There is no such direction, sir.
No, that order,
That read, please.
that interim order,
Page for para 45 again.
para
please read.
45,
Yes.
that in my school.
See, as vague the direction is and as illegal the direction is, so we will have to interpret it as per that. Plain and simple, sir.
My lord,
No going back on that.
I
That
would not,
proposition.
I would not have stand in the way of your lordship for a moment, had there been some appeal against this.
Sir, need
by
not
the
have been.
other side
Yeah,
of
that is why we are saying. You
In
are
that
allowed to
case,
file. You
allowed-
are allowed to file. All right, file it. But they will be considered only if they are
Well,
as per
If
rules.
your lordship interprets this order in that way.
Yes. It deserves no
I
other,
cannot aid anything.
it deserves no other interpretation, sir.
My lord, in
With
that case,
due respect, it deserves no other interpretation.
my lord,
The
Well,
trial, the learned single bench allowed you to file certain documents which could not have been taken into consideration after the last date of receiving the applications.
my lord,
Settled law of the Supreme Court, a series of judgments we can cite right now.
my lord, as I have already submitted, to that extent, I could not have said anything. But,
Your
This
argument is
situation-
that order was not challenged.
yeah,
Now we are saying, read that order. It doesn't say that these additional publications will be considered as a valid submission.
my lord, otherwise,
Yes.
what would be the meaning of this order?
It is me, otherwise also, we are saying, otherwise also this is a meaningless order,
My lord,
plain and simple.
in that case,
Yes.
my lord, as I found it, let me confess before your lordship. The learned single judge ought to have at that time itself, said that, well, a report has come against you. It is your option now. You take a call. We cannot go further.
Yes, please.
Your petition, either you take a call on that, otherwise you are closing it. That ought to have been the approach.
Yes, all right. That is why
And
you have been,
liberty,
that is why you have been given the stretching, the ever stretching rope that you can travel to division bench, even Supreme Court may be thereafter.
there,
This indulgence is totally uncalled for. sir.
that is there, but then it is only for ameliorating the grievance of the petitioner.
Sir, there was no scope for that. You tell us the law, please.
My lord, as I have said, I have already submitted.
An illegal order was not
Well,
challenged by the university. Just please listen to us. A blatantly illegal order was not challenged, interim order, so the division bench is also bound by that.
My
That
lord,
is your argument.
No. Respectfully submit, my lord. Since the others had all considered to this situation,
Maybe,
the learned single just passed an order
yes,
and all other parties accepted it.
yes.
Some benefit conferred on me. Should I give it up, my lord?
Sir, the concession is the remaining journal papers in terms of the advertisement. The terms of the advertisement, you have to read the complete order. Terms of the advertisement by the last date. So this was no
My lord,
concession at all.
My
This
lord,
was not a concession.
my lord,
It was a
I-
very craftily worded
No.
concession.
Lordship, otherwise, as I am saying repeatedly, my lord, repeatedly, at the very threshold,
Yes.
probably the learned single judge should
Sir,
have
we
said
are again
something else.
telling you, this
the
order
threshold.
has neither head nor tail.
Our lordship has gone through the entire judgment of the learned.
No,
single
no,
judge.
we are talking about the first interim
So
order.
lordship has seen this, my lord, how the whole episode developed.
Yes.
Therefore, I need not have to go to it in details. Well, I leave it to your lordship. But my response submission is this. Well,
Yes.
this particular order, once more, kindly read it to me, my lord.
Please, please.
Page 202. Mr. So-and-so, my second prayer I am reading. The Standing Council of the Guwahati University submits that no interview of petitioner could be conducted as he came late.
So
on the
there are
date
two
of
parts to the order.
interview. Yes.
Yes.
However, he submits that before the interview is held with regard to the petitioner, the Guwahati University may be permitted to evaluate the research score of 75 as per criteria given in Appendix 2, Table 2 of UGC regulation.
Yes, please.
He also submits that the Guwahati University has no objection with regard to the petitioner submitting the remaining journal papers
In terms of the advertisement. Now, in terms of the advertisement,
True.
by last date.
That is why I said, well, they have given waived it, they have given this opportunity to me. They have agreed. Learned Single Judge didn't direct, they said that we are agreeing, he can be given. Learned Single Judge seem to approve it. Okay, you go ahead. Then kindly read this again.
Yeah, all right, sir. We have read it.
After hearing the parties, the Guwahati University authorities permitted to evaluate the research scope of
Yes.
75% criteria, even given in Appendix 2, Table 2 of the UGC regulation, and file a report before this court.
Yes.
In the meantime, the petitioner is also permitted to submit the remaining journals, which he could not while making the application against the advertisement dated so and so.
Yes.
So my response submission is, my lord, when they wanted that, yes, he can be allowed to submit because my case was initially on that only,
Yes.
that only.
That there was some impediment which
Yes,
prevented your
prevented
client
me-
from filing those journals.
Exactly, but my, to that
The
extent. only my
process
case-
was stagnated for 2 years.
Exactly.
That is, yes.
My lord, therefore, when the university authority said that they have no objection, they will take it. Court said, also you submit it, but you
Yes.
evaluate it and put it before me. They evaluated it,
Yes.
they evaluated it and put it. Now,
Yes.
whether that evaluation are right or wrong, that
Yes.
is the question. That is the question. And
So now, assuming those journals were submitted,
Yes.
the report is against you, evaluation goes against you. What is the scope? Have you challenged that report?
that is why now I'm coming, my lord, I'm placing before your lord.
Yes, please.
Probably that was the stage where the learned signatures could have stopped. Now, since report has come,
Yes.
we cannot do anything. Take the report, take a call. Fine, we cannot do. Therefore, my lord,
Mm.
the other part, lordship, the learned signatures should not have stopped the matter. That liberty should have been left to me. If I have any remedy against that report, let me
You
seek
didn't
that
ask,
remedy.
as they didn't ask for an appeal against that illegal order, you also didn't ask for liberty. Let us challenge that report.
My lord, I have only, that is the way available to me before your lordship. If your lordship,
You could have filed an application there before the single bench,
my lord,
questioning the validity of the report.
my lord, that is, my instruction is that during the course of argument only that was placed.
Sir, the judgment was reserved on November,
Yes.
in November.
Taking
It
the-
was pronounced in May.
Yes.
So there were 6 months
No,
interregnum between the,
The document was submitted, you have taken
so
and.
you could have
reserved
filed
for
an
judgment,
application. You
ultimately
could have
done.
filed an application.
That could have been
The judgment was not coming out overnight. You
overnight.
could have moved an application.
That is, of course,
There was not even an oral prayer.
that could have been. Well, I have no dispute on that.
So,
But my response submission is, my lord,
yes,
since now it is before your lordships,
yes,
lordships will be,
please. Okay.
lordships' hands are long enough to say
Yes, yes.
that, well, that
Come
part,
come to the aid of such litigant who was originally even not entitled to any kind of relief.
my lord, there are.
That's how
My lord,
the relief should be extended.
my lord,
Equity should no bounds at all.
My lord, lordship, I will have to reply to your lordship since lordship has raised the question.
Yes, yes,
Now,
definitely.
Now, my lord,
Please
can you
enlighten
see,
us.
my whole foundation of my prayer before the learned single judge was that, yes, for some reason, inadvertently, I could not submit all the papers, though I possessed not many.
Yes.
I could submit only 7 that time. It was a mistake on my part.
Mm.
And because of the prevailing situation, that time COVID situation. Therefore, it took 2 years for shortly also to proceed. to go ahead, to ultimately take the whole process into its motion. That was the situation. Therefore, I prayed for. And in the university ultimately agreed and Learned Single Judge allowed it. Therefore, well, here is a case which deserves little concession from your lord.
Very well. Sir. Okay. Thank you.
Deserves little concession under that circumstances. And he is not claiming the post ballot. He is only claiming that an opportunity to appear and contest along with others. Whether he will be chosen ultimately or not chosen, it will be for the authority to decide.
Yes.
I cannot claim, but I want an opportunity. And I was prevented that time from submitting all the papers there because of the situation. And
Yes.
therefore, I will only pray before your lordship now that since that report they have submitted, I may not be precluded from
Yes.
challenging that report if he is so advised in law before the appropriate authority. To that
Yes.
extent, my lord, with a liberty, I ask for this honorable court. Otherwise, your lordship will
Yes.
see that in our.
We will not stall the process. You challenge the report as you law, as you can take whatever remedies available. This process will continue. There is no question of stopping the process.
Probably I cannot ask for also.
So, all right.
I cannot
What-
ask
what
for also
objection do you
because
have?
if my limitation remains there, I cannot proceed further. I will not definitely trouble your lordship with such a prayer.
Maybe in future, it will
Yes.
be relevant.
Exactly. When in future it will prevent me. I am having all this, but
This mess was created, Mr. Das, because of your concession.
My lord, I am appealing for the private respondent, my lord.
Who is this for the university?
My lord, only one thing I would like to clarify, my lord. This concession, if your lordships kindly come to page 109, perhaps, my lord, going back, this is para 5 of the affidavit in opposition filed by the Guwahati University. my lord. 109, my lord.
Just one.
So this concession, with all due respect, my lord, was not the concession of the university.
Where do you read?
Para starts from further.
Yes, further.
Further, it is respectfully stated that since the writ petitioner has submitted only 6 publication papers instead of 7 papers at the time of applying for the post way back in 2020, he has not been considered to be eligible for selection process, including the interview held on 29/7/2020. So that concession was given by the, not by the university, perhaps it was by the council appearing, perhaps, my lord.
Yeah,
Subject-
university never considered in
Because
its
university
affidavit.
never considered, my lord, that you submit application. And your lordship will kindly appreciate, my lord, all along, it was a case, advertisement was issued, my lord. He submitted his application. He did not submit his papers, my lord.
7 papers.
Yes, only on 29/7/2020.
Where is that report which we are,
IQAC report is at, my
IQAC.
lord, page 188. And this IQAC report was produced before the Honorable Single Judge in seal cover. It was open and thereafter it was given to all the parties. And it was given to all the parties. I am just on 17/11/2022.
17/11.
Yes,
So matter was heard thereafter also.
yes.
On
thereafter
24th.
It was heard on, finally heard on 29/11/2022.
29. Where do we get this from? That the report was given on 17/11
Well, there was an order passed on 17/11. I'll just,
from the original.
I'll
written.
just take your lordship.
Do you have a copy? Please let us know.
In the, my lord, order itself, it has been.
All right, maybe in the order
Yes,
itself.
yes. It was reflected there in the order. Right?
Let's read that part of the order. When was the copy provided?
I'm just giving.
But fact remains that they didn't include this report along with their affidavit when they.
Doesn't matter, sir. Do you question the report because it was not with the affidavit?
Sorry.
Do you question the report because it was not filed with the affidavit? It was a
Yes,
sealed
we
cover
raised this.
presented in the court.
We raised this subsequently by in seal cover, they have submitted it.
My lord,
We responded to the affidavit submitted by them. There they indicated about the report, but didn't submit the report.
So
And
what
we,
Mr. Das is saying, the report was presented during hearing on 17th November. Arguments continued till 29th November.
When again the matter came up.
So that by that time you didn't file any objection.
Yes. Yes.
There are
Para-
15, read
my
the
lord,
order.
Page 202, Lordship will kindly take up,
Yes.
second line, my lord. It is already noted above,
Yes.
it is already noted above that the said IQAC report of the Guwahati University was already provided to the petitioner.
Yes.
Page
There is
202.
no scope now, sir, even for that direction.
As such,
You
the
want to
said-
challenge it.
Well, this,
Read para 15, please.
pursuant to the order of the court, Mr. Fukan Lani Standing Council Guwahati University served copy of the IQAC report to respond. My lord, I do not dispute that. It
Sir,
was not
please read,
given.
copy was served
It was given.
on that very day.
On that
10th
period, when
November.
it was produced before the honorable court.
Sir, 10th November copy was served.
Yes.
No, 17.
Huh?
17.
On 17th.
Sir, order says 10th November.
Placed before the court on 10/11,
Yes.
but it was given to all the parties on 17/11. That you will also.
All right, the matter was heard. There was no objection against the report.
That time, no, objection hardly raised, but no prayer was made.
No
that,
prayer. We are
yes.
questioning the report.
Yes, yes. But that report was otherwise, the contents of the report, they are indicated.
So
in
now the
opinion.
only indulgence we can give you is you want to challenge the report, you do it as per law. Otherwise, in this selection process, your role is over.
No, my lord. Lordship may not say that. Lordship may only say,
Yes.
Lordship I will request your Lordship to only say this much, that so far my report is concerned, that is,
Okay, sir, you conclude your arguments.
yes,
Yes, please.
that report, liberty may be granted to me to take recourse to any relief available to me against that report.
Mm.
To that extent, and I am not request your Lordship to pass any order regarding the process.
All right.
That process, if they proceed, they will go. If not, they will not do that. That is on
What is
them.
the objection in that?
I am not saying anything.
So far as the report is concerned, my lord,
Mhm.
the report was already published and circulated long back.
So, all right, if they have any remedy against that, let them avail.
As per law, my lord.
As
Lordship
per
will
law,
not-
we are not
liberty-
giving any liberty.
Lordship will not.
We
give
will say
liberty.
that he is at liberty to challenge the report as per law if so desired.
Yes, ma'am.
That's all, nothing
Yes.
beyond that.
Yes, ma'am.
Because otherwise it will constitute that since this was considered by this honorable court,
Yes.
other court may not.
Not arguing the matter.
That is why I want.
Great length, Then senior counsel, Mr. Manta submits that as the contentious report dated 7 November 2022 issued by the IQAC of the Guwahati High Court, Guwahati University, was presented in the court during the course of the hearing, the appellant could not challenge the same and he might be prejudiced by the conclusions drawn therein, even in his future endeavors. He thus implores the court to leave the petitioner at liberty to challenge the report of the IQAC if so desired and close the instant writ appeal so far as the selection process in question is concerned. The learned counsel for the appearing for the respondents do not object to the said submission, thus, leaving the petitioner at liberty to question the conclusions drawn in the report of the IQAC referred to supra as per law, the instant writ appeal is disposed of.
I am deeply obliged.
All pending applications.
Highly
are also disposed of. Pending applications, if any. है ना, आइए ये वाला disposed.
I is there. I get disposed.
Okay.
Obliged.
Deeply.
May it please, Lordship. Well, otherwise, it appears to be a mercy appeal. Only one question possibly legally I can make, it may be in the nature of a technical issue. The two persons who challenge our appointment manner possibly do not have locus.
Treat it as a PIL, sir.
That's what.
Fraud
My lord,
writ large.
and it's not,
As a matter of fact,
no fraud, my lord. They were appointed temporarily. No
No,
advertisement was.
no. Don't even say so. These are permanent appointments.
No, temporary. Appointment letter itself says, my lord, is temporary.
Read,
My lord,
where is the letter?
my lord. Page-
Whether it is a appointment in pay scale or not. Temporary appointment could have been done on a fixed pay basis. Where are the appointment orders? Read, read.
Maybe there. Page 47, Lordship, may kindly see.
Scale of pay metrics. How could a temporary appointment be there that way?
And it says, so and so is hereby appointed temporarily as LDC in the scale of payment.
Temporary appointment doesn't carry allowances.
But otherwise.
Would you agree to
says,
that?
Time, my lord, yes.
Allowances, concessions as admissible.
Otherwise.
That is why this is fraud.
But it says
In
purely.
the garb
on
of showing it to be a
basis.
temporary appointment, for all practical purposes, it's an appointment against a post.
That is there, but then two persons who challenge, I'm just pointing out, my lord, your lordship.
Hardly makes any difference.
My lord, one says that I only qualify, nothing else. He's not a participant, he doesn't want to participate,
It doesn't make any difference, sir. Doesn't
it's-
make any.
and it is not a PIL, my lord.
Public post,
Petition is not a PIL, man. I know, this is a very
it
purely
could be,
technical
we
issue.
should be
Eh?
thankful to the petitioners for highlighting this
Well,
state of affairs in this
But
court.
if it is a permanent appointment, I'll also not suggest that it should be. But what at this stage, I'm praying for a very small relief, my lord. They will hold a regular
The
selection,
state has the liberty to engage people
my lord.
on contract basis, fixed pay basis, if it so requires.
Right.
If the services are required. Why should we give our imprimatur to that?
And may I make a very small prayer, my lord? Let the state hold a regular selection, fill up the post. Till then, if you're not allowed to continue.
It never ends, Mr. Mazumdar. It continues that way. Then your clients will never allow that selection process to
My
be
lord,
concluded.
fixed time frame, that also I'll say.
It doesn't work out, sir. We have seen not in one, n number of cases.
Once your lordships, kind of fix a time within which they have to complete,
It doesn't happen, sir.
they should do it.
In Arunachal Pradesh, every recruitment, we are seeing what is happening. Papers get leaked, this, that, there are n number of modes.
This time, for the first time, a paper leakage. issue. has
There are
come.
so many mechanisms to frustrate a recruitment process. Sabotage. So that sabotage will continue and these people will continue on the post perpetually. We have decided cases of people who continued for 30 years in the same manner under interim orders of the court.
I'll go further, my lordship may direct them to submit a report before lordship that they have completed within a time frame. So that cannot escape.
We don't go into that exercise, sir. Sorry. So you want our reasons?
No.
No.
Should not trouble the court.
So what we can tell you is that in case a new fresh recruitment is advised, and in case any of the petitioners have become overage, the state may consider relaxing the age. That's what we can say. And Council Mr. Mazumdar, representing the appellants, submits that he may be allowed to withdraw this appeal so far as the order under challenge is concerned on the merits of the matter, but he craves small indulgence that if and when the state proceeds to undertake the exercise of fresh recruitments on the posts which the petitioners were holding in temporary capacity, in case the petitioners may be allowed to, appellants may be allowed to apply in such recruitment process, and in case, during the pendency of the matter, any of the appellants have become overage, they may be allowed to make a prayer to the state for giving them age relaxation. To this prayer, learned Government Council, Mr. So-and-so does not object. Thus, it is hereby directed Thus, comma, the impugned order date so and so is given are full imprimatur and is affirmed as and when, comma, the state, comma, commences the exercise for filling up the post which the petitioners were holding after being illegally appointed, comma, the appellants will be permitted to participate in the selection process in case, comma, any of them has become overage, comma, then such candidate will be at liberty to seek relaxation in age if permitted by law. What is observation? Conspiracy. This, I think they can be allowed to, there's nothing against their conduct, so they can be allowed to participate. With the above observations, come on, the instant writ appeal is disposed of as withdrawn.
We have gathered some experiences in the meantime, they can consider their, that's just the experience that we have.
We don't know there are marks for experience or not, we don't. Yes. In terms of the rule, they'll do it. If at all there are any marks for experience, they will consider it.
Rules do not say. I've
So
checked.
then if there are no marks for experience, then what is the point?
Deep.
Yes.
My lord, we have Thank you. May it please your lordship.
Yes.
Lordship, we had given an adjournment slip, my lord. We need further 2 weeks' time to file an affidavit, my lord.
And counsel, Mr. Your good name, please?
SP Sharma, my lord.
SP Sharma, appearing for APSC,
For EPDC, madam.
APDC, raised for his
For respondent number 3 and 4.
further opportunity of 2 weeks to file affidavit on behalf of such respondent. The others are also not filed as respondent.
I am appealing for number 1.
Do you need, do you want to file affidavit?
And thus.
Mr. Endasan is deeply obliged. Normal course, this is the whole thing, are hearing at 11:30.
Next, which is appealed by the Central Excise Department against the order dated 30/2017. Lordship, on 20th of February 19, 2 questions were framed,
Yes,
20/2/2019. Lordship.
just. Mm. Put in February 2022,
20th of February 19. Lordship.
19.
Lordship.
Yes,
Lordship, first question was whether the CSET was justified in concluding that the exemption as granted to the respondent was justified, and in that light, whether the conclusion.
exemption.
Yes, Lordship.
Yes. is as reached is perverse for non-consideration of the evidence said to have been produced by the appellant the hearing. And second question, whether the order is perverse and that regard to whether the CSAT has taken into consideration the materials available on the record.
Frankly speaking, these are not questions of law. They are as good as saying the order of the CSAT is illegal. Precise formulation on question of law. That is what is expected. Anyway, forget about that. Come to the merits. Lordship, may come to this directly to the statement of the managing director of the company, Lordship, page 27. Why don't we read the order of the CSAT first? Page 70, lecture 6. 70, Lordship. 74, paragraph 6 is the finding of that. Page 74, paragraph 6. Just heard both sides and peruse the record. The notification number 32 of 99 dated 8/7/99 granted the area-based exemption was amended by notification number 5 of 2002 and dated 12/2/2002. After that said amendment, the site in which the appellant was situated was covered within the definition of industrial area, and the appellant became eligible for such benefit. The claim of the appellant for the benefit of notification was also considered by the jurisdictional deputy commissioner and approved by order dated 10/12/2002 with effect from 12/2/2002. The said benefit was withdrawn by impugn order on the basis of investigation carried out against the appellant. During the course of investigation, Sri Rishi Gupta, managing director of the appellant, submitted a list of machinery dated 89/2002 along with copies of relevant invoices, bills and claim that their machineries were procured in the year 2000 and installation in the factory premises before commencement of the manufacturing unit of the appellant. With the help of jurisdictional central excise authority, the department carried out investigation during which the wheels were found to be fabricated and false, and further that no machineries were supplied to the appellant under the respective bills. On the basis of such investigation, it was concluded that no new unit was set up and no substantial expansion was also undertaken. From the record of the case, it is seen that the application of the appellant to the jurisdictional central excise authority for granting of benefit of area-based exemption was duly considered by the deputy commissioner. After verification of the application and connected records, the benefit was allowed by deputy commissioner's order dated 10/12/2002. It has been clearly recorded in the order, para 5, that the factory was visited and it was found that the plant and machinery as declared by the SSC was in operation. Further, it was verified and confirmed that the commercial production of the unit was started on 25/5/2020 on 25/5/2000. After verification of the connected record, the benefit was extended by the above order. Surprisingly, the investigation which has led to the withdrawal of the benefit of the notification was commenced as late in 2005. The department has sought the list of machinery which was procured and installed before the grant of notification. The investigation focused on establishing that the invoices under which the machines were said to have been procured were false and fabricated, and that no machines were found to have been supplied to the appellant. At the time of visit of the office to the factory in 2002, all the machineries were found to be installed and working. Based on such verification, the benefit has been. What was the investigation after 3 years? What was the reason for undertaking the investigation after 3 years? Lordship for ordering so-called notice. Lordship, page 15 to 21, demand notice. Page 15. 15, demand notice. Yes, sir. Demand for withdrawal, recovery of exemption advantage given, exemption benefits. Okay. Let's see. That's paragraph 2, page 15. Paragraph 2, yes. Whereas acting on an intelligence, the officer of the headquarter anti-aviation Central Excise Shillong, Guwahati, have visited the factory premises of the said RTP at Lohra, National Show, and conducted on 18/10/2005 and conducted an inquiry which revealed that prior to 24/12/97,
an industrial unit in the name of and style of Polyplus products was functioning on the same plot of land bearing tag number so and so. Betkuchi manufacturing PVC installed copper and aluminum.
The relevant part, these are just,
Yes, but see, this was the reason for inspection. Lordship. And during inspection, it was found.
there is no reason. Intelligence, what was the intelligence? Reason is not given. Just acting on an intelligence. Others, thereafter, there are just the basic facts, how the unit came into existence.
Lordship, page 16,
Yes.
third paragraph. Lordship, we come to second paragraph also.
Page 17. Very well.
Whereas an SIC registration certificate bearing number so and so was obtained in the name of said RTP, a partnership firm, where Sri Rishi Gupta and his wife Srimati Anita Gupta are partners from District Industries and Commercial.
Come to para 17, page 17.
No. Whereas during investigation, the said RTP have claimed by the statement dated 21/11/2005 of Sri Rishi Gupta managing partner that the machineries were purchased in 2000 in the name of the said RTP and the same were installed in the factory premises of Polyplus. The said RTP have submitted a list of machineries by number so and so with a copy of invoice bills detailing in Annexure B. The copy of the bills invoices were sent to the jurisdictional Central Excise Authority at Calcutta, Commissioner Ludhiana, Commissioner so and so for verification of genuineness. During the verification, it revealed that the copy of the said invoices in respect of the machines of the said RTP as claimed by Sri Rishi Gupta have been purchased are found as false, forged and fabricated, except invoice bill at serial number 8 and 9 and except B. The machineries at serial number 8 and 9 were purchased in the year 2003 for new products. Then details of verification. Joint Commissioner AE Central Excise Calcutta has submitted a statement dated 26/6/2006 of Sri Mukesh Gupta, proprietor of Bintu Plastic Industries, Calcutta, wherein Sri Gupta has stated that he is not manufacturer of 65 mm extruder machine and he never supplied such machine to the said RTP. Then 2, Superintendent of Central Excise Patiala, Division so and so, has submitted a statement dated 16/5/2006 of Sri Vijender Singh, proprietor so and so. Wherein Sri has stated that he never supplied any machine to the said RTP Guwahati and also stated that the said RTP has misused their name. He also termed the copies of the invoices fabricated and false. In paragraph 18, page 18, Lords. Joint Commissioner Delhi had submitted a statement dated so and so of Sri Ajit Singh Saini, proprietor of Saini Engineering Works, wherein Sri Saini stated that he never supplied any machine as mentioned in bill for rupees 18,10,047 and 14 the said RTP, and they have never dealt with the said RTP and also termed the copies of the bills as fabricated and false. Similarly, paragraph 4, subparagraph 4. The Superintendent Central Excise Patiala, Division so and so, by the report dated 9/1/2006 has submitted a statement dated 4/1/2006 of Sri Bajinder Singh, proprietor of Krishna Industry Corporation, Rajpura, Punjab, here said Singh has stated that he never supplied any machine to the said RTP Guwahati. He stated that the said RTP has misused their name and also said that no such transporter in the Rajpura in the name of Sunil Transport. Whereas in term of clause 3 of the exemption notification has amended only new industrial units which have commenced their commercial production on or after 24th day of September 1997 can avail the benefit of exemption under the said any notification dated so and so has amended. The clause 3 of the notification number 32 of 97 is reproduced. 3. The exemption contained in this notification shall apply only to the following kinds of units. A new industrial units which has commenced their commercial production on or after 24th day of December 1997.
an industrial unit existing prior to 24th day of December 1997, but which had undertaken substantial expansion by way of increasing in installed capacity and not less than 25% on or after 24 December 1997.
What is that so-called confessional statement
Lordship,
you referred to in this order?
yes, Lordship, page 27, Lordship, the translated copy.
The first statement, he doesn't say anything. The
Lordship,
statement at page number,
Page 27 is that there are five statements.
the first statement at page 27, therein this admission is not there. Where is that admission part of the statement? Section 14,
And central exchange registration certificate obtained from on being asked, Sri SI registration.
page 34,
Lordship, page
34,
27,
34. Obviously, they themselves say that the unit came into existence in 2002.
Lordship, that was another unit. That
No,
was
no.
closed and new unit was.
They
And
came into existence on the very same plot of Polyplast. There is not a dispute.
Lordship, what happened, the exemption was withdrawn because they said that they have procured the machines from different purchasers and
And
suppliers.
you found from the purchasers that they never
They
transported
did
them.
not transport, even they are not dealing with such type of machine also.
What is your case, sir? Mr. Saraf, Dr. Saraf?
The question is that before the tribunal, my lord, the tribunal has taken into consideration whatever facts are there. On the basis of those facts, the tribunal came to finding. Now, when you'll also be examining the question on the basis of substantial question of law. In my humble submission, the court will not appreciate the facts and come to a conclusion that whether those facts which were arrived at by the tribunal were correct or not, or whether that can be, my lord, said to be not. The lordship is aware, my lord, that in many cases, number of cases, my lord, I will place one judgment before the apex court, or my lord, before your lordship.
Yes.
Lordship, may kindly see, my lord, para 26,
46,
25, my lord.
25.
I will also take to para 26 minutes. Relying on the decision of this court in so and so, Mr. Yes, Ganesh in so and so is submitted that the issue relating to the property of the legal
Propriety.
propriety of the legal conclusion that could be drawn on the basis of the proof facts give rise to a question of law, and then the High Court is justified in interfering in the matter since the authorities below failed to draw a proper and logical inference from the proof facts. We are unable to persuade ourselves to accept the submission. The findings of fact arrived at by the authority below are based on proper appreciation of the facts and the materials available on record and the surrounding circumstances. The doubtful nature of the transactions and the manner in which the sums were credited in the books of account maintained by the SEC have duly been taken into consideration by the authority below. The transactions, though apparently were held to be not real ones, maybe the money came by way of bank checks and paid through the process of banking transactions, but that itself is not of no consequence. no question of law, much less of substantive question of law had arisen for consideration of the High Court, and the High Court misdirected itself in examining so and so on. In this case, the reverse was the case, my lord, where the tribunal, my lord, found that, my lord, that the transactions were not genuine. And the SEC contention was there that, my lord, the transaction was genuine because the money came through bank and all those things. The High Court said, the Supreme Court said, my lord, that these considerations are not material at all. Because whether they were bogus, whether they were not bogus, these cannot be give rise to a substantial question of law. Because after all, the question which is to be arrived at is on the basis of the facts as found by the tribunal. Now, the facts which have been found by the tribunal, on the basis of that, my lord, the question of law will arise. Now, on the basis of finding of the tribunal, my lord, which para 24, 25, which my learned friend placed before lordship, whether it can be said that any substantial law must said, well, the substantial question of law, my lord, not to speak of the question of law, whether arises for consideration before this honorable court. Now, we'll also see, my lord. Well, you are actually aware, my lord, that whenever the perversity question only is said in question perversity, that itself, my lord, will not say that the order is perverse. Now, we also see para 10, my lord. It is known, my lord, that if the perversity is proved, my lord, then the question of law will arise. But you will also see reference to the question para 10, my lord.
Yes.
Reference to the question of the question to the High Court as noticed and above was general nature. No question was referred as to whether the finding of the tribunal was perverse or not. The existence of mens rea is essentially a question of fact. The tribunal alone has the highest authority empowered to determine the question of fact, which would be entitled to go in thereinto. Maybe, however, hasten to add that the same would not mean that the High Court will have no jurisdiction in this behalf. The High Court, it is well known, should not ordinarily disturb the finding or the fact arrived by the tribunal. Question of law should generally arise only after accepting the finding of fact to be correct. So if the finding of fact are treated to be correct, then, my lord, in my humble submission, no question of law at all arises for consideration. Otherwise, my lord, in every case, my lord, if the under the grab of the substance of question of law, my lord, the courts, High Court or the Supreme Court, my lord, is asked to go into the every, my lord, take up the role of the, my lord, the assessing officer or the assessing authority to examine whether they, my lord, they were correct or not. My lord, ultimately there will be no end to that. Then everybody can, my lord, go for it, my lord, and determine. Now, one question is,
First and foremost consideration in this case, your investigation was after 3 years.
no, that is correct, lordship.
And when what was the status when you initially inspected? What was your report? That your assessment is silent.
Yes, lordship.
So 2002, when your own officers made the assessment and granted the exemption certificate, what was the status?
Lordship.
It can be presumed that your officers inquired, verified, and then only granted. So have you cast an aspersion on the earlier report in your investigation? Read that.
Lordship,
No.
in original.
It doesn't even refer to. Does your assessing authority refer to the verification made at the time of grant of exemption?
And lordship, further see, my lord, in many cases of the case criteria, lordship, coming across the cases where the, my lord, after 4 years, the person concerned brokers and sharers, they say that we have not done in all those things. The High Court, Supreme Court said, no, on that ground itself, somebody said that I had not done it after 2-3 years. On that ground itself, the person cannot be because the transactions were there. If after 5 years, 4 years, somebody says that, no, I have not done
That
it.
is, that statement which you record is a unilateral inquiry.
Without.
The SSC has no role to play.
No,
You go and record the statement of anyone, XYZ,
No, if opportunity was given to him, he
cross-examine.
No.
Are you sure?
That type too.
That inquiry, he was not a part to that inquiry. That is your unilateral action. After 3 years, that is a good ground to question the doubt of, to hold that inquiry is doubtful.
In one of the cases before this honorable court, I'm just saying, the allegation was that cow dung was purchased for crores of rupees by the tea garden. And after the expenditure was allowed, after 3-4 years, where from person who supplied the cow dung, he was research was made and he said, I have not supplied. Somebody else has supplied. They went to him also. He said that, no, I never supplied. I only used to, raise the bill and 10% was given back to me. On that ground, my lord, the assessment of my was reopened. This honorable court said that no, because so far as my books of account are concerned, the expenditure has been claimed, it has been allowed on the basis of that person saying only that, no, I have not done it.
That's what
How
the
can you
issue is.
disturb?
A third person comes and says, I didn't supply.
Everybody will
What
say
is the
no.
veracity? What is the test before the court to find out that you went to the correct man?
And a person who is number two doing the things, he will always say that I've not done it.
No, Lordship, that was the finding of that inquiry report. And
Inquiry was unilateral. It was not a bilateral inquiry.
Lordship may come to page 76 of. tribunal.
Yes, we are on that only. Blank statement.
Lordship, page 76, paragraph 9.
Yes, we are reading that only.
It has been observed by the adjudicating authority that the appellants made use of plant and machinery originally installed.
So that is what we are saying.
No,
When your authorities made the verification in 2002 and granted the exemption, at that time, whether that was the observation, that no, these are old machines. There is no expansion.
That was not.
Where is that report? That is not even considered. Verification report at the inception.
Lordship, paragraph 10 for.
9 of
Yes.
the last 3 lines also.
In the light of the above discussion, we conclude that the investigation undertaken can at best be raise doubt in the mind of the prudent man that
Yes.
the benefit of verification might have been misused. But the evidence on record would not justify the. withdrawal of
Precisely.
the-
That is what we are saying. Your adjudication does not even take into account the original report. Have you cast any doubt on that? They were also your officers,
Yes,
your
Lordship.
peers.
Yes, Lordship, that is.
So an investigation inquiry done 3 years later, recording the statement of a third man, XYZ.
No, Lordship.
Tell us, your investigating officer was able to contact the correct man, the proprietor of that very firm. What is the veracity for the court to arrive at that conclusion?
The tribunal had dealt with me, Lord, the last 4 lines of para 9, my lord.
Yes.
Whether the entire case has been built up on the basis of the statement of the suppliers of the plant and.
Yes,
machinery.
corroboration,
In the absence of any documentary corroboration as such, the statement.
oral statements, whether you have brought their statement of account for the relevant year, that such machines were sold or not. Bald statement.
Lordship, page 56, the order in original,
Yes,
paragraph 1.1.6.
read please. Read. What is the documentary evidence? Where are those, their bills and invoices and registers of those sellers?
Yes, Lordship, that is.
Have you considered?
Then 1.7, it speaks about
Hmm.
the verification of the.
Statement of Mukesh Gupta, he is not manufacturing.
Lordship,
So where are his books of accounts, the manufacturing details collected?
Lordship, paragraph 1.9, page 57.
Yes,
Sri Rishikanta was also integrated on 21/11/2005, 23/11/2005, 28/11/2005,
yes.
and 36 of 2005 by summoning him
Hmm.
under section 80 of the Central Excise Act. And in his statement dated 23/11/2005, he stated that there was no physical existence of Mrs. Rajdhani Teleproducts till 31/1/2002 on the said plot of land, but goods were cleared in the names of the said RTP to show its existence.
Hmm.
Sri Rishigupta has also stated in his statement dated 28/11/2005 that the production started in the name of said RTP after obtaining the central excise registration.
Yes. So obviously,
So he was.
production will start thereafter only.
No, Lordship, his statement,
Yes.
he was given opportunity, Lordship,
Hmm.
4 occasions, Lordship. And he was in.
So he has said, yes, RTP started production after getting the registration.
But
What is wrong in that?
with regard to that polyplast,
Hmm.
there was no existence of the RTP that Rajdhani.
2002, they took the registration, then started production.
That was in the another name,
Another,
company, the polyplast. Lord.
that very unit they have started. It is the same unit. That is what the finding is.
They did not use the machinery of polyplast.
But on integration, Lordship, and on the verification, it was found that these machines were of all machines. He has not.
There is no such finding. That is why we are asking you, where is your only original verification report? It would have been observed, old machinery. What were your officers doing then?
That is.
They were greasing their palms. Seems so.
That's it.
Well, can I please? Well, can I please one or two judgments more, Milord? Because I bought it, so I thought they blood.
Please do that. Arguments are judgment is out.
Para 5, Milord.
Hmm.
We are unable to agree with the learned council. What can be subject matter of examination and appeal under section 260A of the Act is a substantial question of law. The test to determine whether substantial question of law in case substantial question of law or not was laid down by the 4 decades ago by Constitution Maintenance Council. It was said that the proper test would be whether it is so I'm not skipping over. The last point, the mere apprehension, appreciation of the fact, the documentary evidence of the meaning of the entries and the contents of the documents cannot be held to giving rise to a substantial question of law. My lord, in the next case, in fact, the issue which is there that was decided by the division bench of Tripura High Court, same issue, my lord. And the department has carried the matter to the Supreme Court by way of SLP.
So let's wait.
I think that will be better. because I can
Stated.
give the last
Dr.
order of
Saraf
the-
submits that the issue involved in this appeal is pending consideration of Honorable the Supreme Court in another matter arising from a judgment of Honorable Tripura High Court. Can we have the number?
Yes, my lord, especially civil, I will give the number, my lord. 3116 of 2023.
This list after 8 weeks awaiting the outcome of the matter pending before Honorable Supreme Court. Okay.
I will give the copy of the order also.
दे दे 5 to 31 डेट दे देना इनको चाहिए. The last page. There's a bunch at the end. They had asked for an adjournment. दे देना दे. Okay, ठीक है लिख देना. This will be in that. This will be the next. In 21.
Item 21.
Okay, very well. The affidavit, that is the stamp. I take the stamp, the statement of the lawyer is there. Yes,
I'm available.
yes. Give the dates in the other matters if they wanted. Yes.
Even the adjournment slip, your lordship, in the morning, your lordship.
Why do you want an adjournment?
I had some personal difficulty today, your lordship.
All right, I'm counsel, Mr. So and so. What's your good name?
C.S. Hazarika.
C.S. Hazarika appearing for the respondent. Place for time, list after 3 weeks. Mr. KL has no objection. 25 to 31.
Actually, in this case, how that I'm not appearing as
You're not appearing.
Mr.
Mr. KL submits that now, Mr. Arkadev Chaudhary, Deputy SGI will be appearing for Union of India in this petition. Name of Mr. Chaudhary shall henceforth be reflected in the call list. Yes, 25 to 31.
My pleasure, lordship, 25 to 31, I praying for adjournment, lordship.
Why? What is the matter, Mr. Mozumdar?
My lord, here they have challenged a provision of law which does not mandate that B.Ed should be a qualification for assistant headmasters, though it is a qualification required for headmasters and teachers.
Okay.
We have explained it, my lord, they had got an interim order. Considering our affidavit, the interim order was vacated.
Vacated. So academic exercise basically,
Almost.
more or less. All right. 4 weeks as right.
I'm obliged.
প্ৰকাৰৰ নামটো লিখিবি সেইটোকে আপুনি জানা আপুনি ভাইটিৰ নাম লিখিব লিখিছে মই ইয়াক কৈছো প্ৰকাৰৰ নাম ভাইটিৰ নাম লিখে
You so much. মই এডু লিখি দিলে হলো ইডিউ লিখি দিলে এটা কাম কর